A couple of housekeeping matters. First, there are 4 bills that will go by for the week at the request of the patrons. Senate Bill 1342 from Senator DeSteff, 1230, Senator Eben, and 2 of Senator Saslaw's bills, 1164 and 1467. So those, without objection, those 4 will go by for the week. I would hope that we can minimize taking bills by so that we can continue to plow through this. Now, I understand there's circumstances beyond control of the patrons. We also have Senate Bill 1570, Senator Lewis's bill on adult protective services. This is a bill that needs to be re-referred to the Committee on Rehabilitation and Social Services. Senator Stanley moves, Senator Saslaw seconds that bill be re-referred. All in favor signify by saying aye. Aye. All opposed. That bill is re-referred. We have a couple of scheduling issues, and in order to accommodate those, first thing that I want to take up are Crime Commission bills. And I believe that we have on the docket today, Kristen or Colin, what do we have? 1603?
1603 and 1649, Mr. Chairman.
Okay. Well, let's take up 1603. Senator Stanley, would you take the chair?
All right, the committee will rise. Once again. Okay. Senator Obenchain.
Of years on sex trafficking and making sure that we have effective strategies for combating it. We in General Assembly have adopted legislation over the course of the past several years, but the Crime Commission has taken a close look, and this Senate Bill 1603 was the unanimous recommendation of the Crime Commission this year. The Crime Commission found that commercial sex trafficking continues to be a serious problem, and after extensive research and testimony, this bill does 5 things. And Crime Commission staff, Colin Drabert and Kristen Howard, are here and are better equipped than I to answer any questions the committee has. But let me tick through the 5 general things that this does. First, it amends the commercial sex trafficking statute to permit charging commercial sex traffickers for each individual act of promoting prostitution. The problem has been that there are many offices around the Commonwealth who have just not been incented and have not prioritized the prosecution of sex trafficking. And this is a measure to make it clear that these are serious crimes that need to be taken seriously. We have cases of child pornography and others where each individual photograph is considered to be a separate count, but acts of prostitution involving often minors are not treated as separate incidents, and we, Crime Commission, determined that these ought to be treated at least as seriously as the pornography cases. Second, it increases the penalty for aiding in prostitution and using a vehicle to promote prostitution, changes that from Class 1 misdemeanor to Class 6 felony when the victim is a minor and the offender is an adult. The third thing that it does is that it amends the prostitution and solicitation of prostitution statute to prohibit touching of private parts, which is an omission that definitely needs to be remedied. Fourth things that it does is it allows juvenile victims and witnesses of sex trafficking to testify via two-way closed-circuit television. Within the existing statutory framework. It doesn't change the framework. It simply enlarges it to permit these classes of witnesses to testify. And fifth, it creates a Virginia Prevention of Sex Trafficking Fund to be administered by the Department of Criminal Justice Services to promote training, education, and awareness of sex trafficking. So as concisely as I can possibly describe it, that is the bill.
Thank you, Senator Shane. Are there any questions? The patron? Hearing none. Do you have anybody you'd like to make a further presentation?
Sorry? Oh, there is a line amendment. Charles?
Let's get that in order.
Kristen?
Strike
Colin?
solely, yes. On line 26 of the bill, strike the term solely.
I so move.
A motion and a second properly supported. Is there any discussion on the line amendment? Everybody understand the line amendment? All right, all in favor of adopting the line amendment, please signify by saying aye. All opposed, same sign. And that amendment is part of the bill now. Is there anyone who'd like to speak in favor of this legislation? Senate Bill 1603.
Mr. Chair, Nancy Parr, Commonwealth's Attorney for the City of Chesapeake, here on behalf of the Virginia Association of Commonwealth's Attorneys, and we support this bill for all of the reasons that the Senator has stated.
Thank you. Thank you for coming.
Good afternoon, Mr. Chairman. Shannon Taylor, Commonwealth Attorney for Henrico County. Not speaking on behalf of VACA, but as for one of those jurisdictions who is very actively involved in prosecuting human trafficking cases, we are in support of this bill. My deputy, County Manager Mike Fallon-Mel, was part of the Crime Commission Committee group, and we would hope that this committee will endorse. Thank you very much.
Thank you, Ms. Taylor. Yes, sir.
I'm David Westcott with the Family Foundation, and we support everything for this bill.
Okay, great. Thank you. What about casino gambling? What do you think about that? Asking for a friend. Just asking for a friend. 2 friends. All right, is there anyone else who'd like to speak in favor of the legislation? Is there anyone who'd like to speak against the legislation?
Good morning. Good afternoon, Mr. Chairman. Patrick McKenna, Virginia Beach Justice Initiative and Hampton Roads Coalition Against Trafficking. We are ostensibly in favor of the bill, except we'd like to see sex trafficking actually broadened to human trafficking, but we've talked with those at the Crime Commission, and first I want to say what an excellent job the Crime Commission did related to studying and putting this together. Staff has done amazing work, so in that regard, I appreciate it. We work directly with sex trafficking survivors. Presently working with over 80. And my major concern is really with the amendment of 18.2346, which deals with solicitation and manual stimulation. I believe the way the bill is presently configured, in that particular portion of the bill, we're going to end up re-victimizing victims. And that because survivors will be the ones, the victims of trafficking, the way the bill is presently configured, they will end up being the low-hanging fruit, so to speak. And they will be the ones, I think, that will be first gone after as opposed to getting a demand. I believe there's an easy fix to amending the bill to removing certain language from the front part of Section A and moving it to Section B and focusing simply on those in demand and their attempt to get somebody to do manual stimulation. But other than that, we are in favor of the bill.
Okay, thank you, sir.
Mr. Chairman, I understand what the gentleman is getting at. What we heard from witnesses who appeared before the Crime Commission, primarily law enforcement and those involved in combating human trafficking, is that this is not a simple problem. It's a multifaceted problem. Very seldom are the victims ever prosecuted for these crimes. However, many of these victims are folks who have been brought in and groomed and do not view themselves as victims. And this is an important tool for law enforcement and social services to have available to make sure that they have the leverage necessary to get the services to the victims. And this is a debate that we've had over a long period of time, but law enforcement consensus was, in this instance, this tool really needs to remain in the statute in order to help victims get the services that they need. So I agree with the sentiments of the gentleman, but I don't think that the amendment is one that we should make.
Thank you, Senator Obenshain, for clearing that up. Anyone else like to speak for or against the bill? Hearing none. Motion to
Second.
report as amended being made, properly seconded and supported.
Finance.
And if it is, the motion needs to be amended because it's re-referred to finance. Is that your motion, Senator Edwards? Yes. I insist. All right, so the amended motion is to report the amended bill and re-refer to finance. Senate Bill 1603, it's properly supported by a second. Is there any discussion on that? Hearing none, clerk open the roll. And close the roll. Whoop. Deeds. Who has the deeds? Peterson, deeds. Clerk, close the roll.
Ayes 14, no zero.
Ayes 14, no zero. That bill reports, Senator Obenshain.
And Kristen, what's the other Crime Commission bill?
1649, Senator Chafin's bill.
I could stay here if you want. I can stay here if you want, Senator Obenshain. I'll sit right here. It's fine. It's nice. It's very nice. I mean, it's not local government, but it's nice.
Mr. Chairman,
Senator Chafin, welcome.
this is another crime committee bill, and basically, this bill, while we have a lot of good bail bondsmen out there that our clients rely upon from time to time when they've had the unfortunate incident of being arrested and incarcerated, this bill would be a bill that would seek to perhaps save them from themselves, from some of their worst behavior. And the only thing this bill in particular does is it increases the penalty to a felony, takes it from a Class 1 misdemeanor to a Class 6 felony, and that's what this bill does. It's already unlawful behavior.
All right. Anybody wish to speak in favor of the bill? Ms. Parr?
Mr. Chair, again, Nancy Parr here on behalf of VACA, and VACA supports this bill. This paragraph is really addressing people who really their freedom could be very well at stake, because if they don't agree to do what their bail bondsman wants, they have the opportunity to revoke their bond and put them back in jail. So their freedom really is at stake here if they don't perform these forced or coerced sex acts. So we support this bill.
Thank you. Ms. Taylor?
Good afternoon, Mr. Chairman. Shannon Taylor, Commonwealth Attorney for Henrico County. I regret that this bill came out of an incident that occurred both in Henrico County and in Prince George County. My colleague, Susan Fierro, who actually used to work in my office, who's the Commonwealth Attorney in Prince George, helped with the cooperation of Henrico authorities to build a case against this bondsman who, let's just say, took his own liberties with numerous women who were at nothing but at his mercy to engage in certain sexual acts. Otherwise, they would be placed back in jail. It was so egregious that in one case, he had bonded a young lady, took her to the parking lot of Henrico County Courthouse, demanded a sexual act, and told her he would march her right back in there if she had not. And in fact, she did not perform that act. But this idea of allowing it to be a felony gives law enforcement the ability to expand the time frame that we can conduct these acts, because these individuals should not be in that position of authority.
Yeah, and one other thing that we learned through the Crime Commission study was, and you know, Ms. Taylor, this is not the world in which I practice, and so all of this is educational for me, but I learned that bail bondsmen have the ability to have bond revoked for any reason at any time.
Yes, sir.
And to have that kind of power and not make this a felony is deeply troubling, especially when confronted with the situation that you described. So thank you.
Yes, sir.
Appreciate
Thank you,
that.
Mr. Chairman.
All right. Kristen or Colin, do you all want to add anything? Okay. Oh, thank you. Senator Chafin? Anybody wish to speak in opposition to this bill? Bill is before us.
Move to report.
All right, it's been moved and seconded and re-refer to finance, of course. Oops. There we go.
Ayes 14, no zero.
All right, the bill reports and is re-referred to the Committee on Finance. Senator Cosgrove. Thank you.
Good afternoon, Mr. Chairman.
1048,
Yes,
I
Mr.
believe.
Chairman, this is a fairly simple bill. I hope it won't be too much of an imposition on your committee.
That's what they all say.
I know, but I mean it. Mr. Chairman, what this bill does is just puts auxiliary law enforcement officers who have 10 years of service into the same category as regular active duty law enforcement officers when it comes to purchasing their service weapon. Right now, the sheriff or the local police department has to have a written guidance, written something from the locality. Regular police officers aren't under that same umbrella, and this would just treat the
Allows the
auxiliary.
chief
Yes.
to make that call.
Yes,
I
sir.
think the bill is in good order, and unless anybody has any concerns about the bill, bill is before us. It's been moved and seconded to report the bill. The roll is open. All right.
Ayes 14, no zero.
The bill
Thank you, Mr.
reports.
Chairman. I
Thank
appreciate
you. Senator Eben has Senate Bill 1008, and he has requested that that bill be stricken. Senator Stanley moves, Senator Sasslaw seconds, that bill be stricken. All in favor signify by saying aye. Aye. All opposed, that bill is stricken. No other patrons. Anybody on the committee want, see Senator Howell, 1096? Okay. Oh, hey, Janet, Dick's got to go somewhere, I think. Can we, Senator Sasslaw? Senator Sasslaw, we have first 1162.
Mr. Chairman, members of the committee, 1162 essentially does two things. It's the background check bill, plus raises the buying age in Virginia to 21, and it does it gradually. In other words, if you turn 18 prior to July 1st of this year, you're eligible from here on out. And then 19 the following year. So it takes 3 years to raise it to 21. Several states have already done that. Florida is one. And interestingly enough, the President Trump has said that the buying age should be raised to 21, which, as you know, for
Is that compelling to you, Senator?
it ought to be compelling to some other people in this room. But anyway, you know, and somebody said to me, well, you know, by doing that, you're depriving law-abiding citizens from buying a gun. I'm the one in the mid-'80s that raised the drinking age in Virginia to 21. And we did. I'm the one. I'm the one. And let me tell you, I had to be escorted out of a high school because these kids were so furious. But, you know, I pointed out to them, 98% of the people who were, you know, 18, 19, 20 years old weren't getting in a car, driving drunk, and, you know, injuring other people. But yet we had to take, you know, they got deprived of the right to drink because of the other 2%. However, I don't think anybody in this room has ever heard of an 18 or 19-year-old going into a high school and killing 17 people with a beer bottle. And you know, federal law, I think federal law, the way it's constituted now, if you buy a handgun from a licensed dealer, I think you have to be 21. If it's bought from a licensed dealer, now for a rifle, or they refer to it as a long gun, you can be 18. And if you buy a handgun from a, you know, private citizen, it's 18, I think. So it's not 21, I know that. So what 1162 does is it moves the age gradually to 21. And it requires a background check for any firearm transfer, and requires the Department of State Police to establish a process for transfer of firearms to obtain such a check from licensed dealers. A transfer who fails to obtain a background check and transfer the firearm to another person is guilty of a Class 1 misdemeanor. And ultimately, I think that drives some of these bills have to go up to finance at the minimum $50,000 impact. But there's quite a few exemptions in there. Between immediate family members, that would be exempt. That occur by, you know, within the operation of existing law, the executor of an administrator or estate, by the trustee, that's exempted, that occur under a voluntary gun buyback or give back program, antique firearms, those transfers that occur at a shooting range or shooting gallery. So there's quite a few exemptions in there that cover situations that people have discussed. So that's essentially what it does. It's not taking guns away from law-abiding citizens. It just, you know, we're recognizing the fact that we got a problem in this country and we need to deal with it. I was in the Army, like a lot of you in here, fired everything that you could imagine. Some of these weapons, you know, probably ought to be in the hands of it should not be in the hands of civilians. And I'll tell you something else. You can't walk around a military base with a gun unless you're either on duty as an MP or on your way to a firing range. Now, they're unloaded. You don't have, I mean, you keep your rifle in, you know, your rifles was in the existing barracks, but the ammunition wasn't there. So, you know, that's why, generally speaking, with the exception of the incident that occurred a few years ago at Fort Hood, you generally don't see this occurring on military bases because you're not allowed to carry, you know, loaded guns or your own personal guns around on a military base. So anyways, this is what the bill does.
Senator, since you're talking about the military, I mean, this does not have an exemption for military. So if you're 20 years old and have been in the military for 2 years, you still would be covered by this and prohibited from.
That's correct.
Okay.
And by the way, you know, if you remember, one of our senators had a bill to exempt people who were 18, 19, and 20 in the military several years ago from our, you know, a concealed weapon permit law. In other words, they could get one because you have to be 21 in Virginia, I think, to get the concealed weapon permit. The problem, as I pointed out to the individual, is what does he do when he gets back to the base? He can't bring that gun on the base. He'll wind up busting rocks at Fort Leavenworth. So anyway, this is what it does.
All right. Well, let's hear from witnesses in support and opposition. And and I would point out, remind people that many of these bills are not new. The composition of the committee is identical to the composition last year. We're going to impose time limits, and I was hoping that the timer had a 3-minute limit on it, but we'll go to, why don't you do a 4-minute limit? We're going to have a time limit. Understand that the people behind you in line, and Mr. Goddard, I know, is familiar with the committee, but people behind you in line aren't going to get to speak if you use all of their time, so you may want to confer with other people in line, and this is for all of the bills. So first, we'll hear from people in support of the bill. Step right up.
Hi, Josh Horowitz with the Educational Fund to Stop Gun Violence. Thank you, Mr. Chairman, for giving me this opportunity. I'll make a couple of quick points. people between 18 and 21, there's a lot of new science that has shown that their brain chemistry is not developed to full maturity, and so that's important to make sure that they don't have access to lethal means. Number two, this is an age group that is quite at risk. In 2017, 1 in 5 adults arrested for homicide was between 18 and 20. In the last 10 years, half of 18 to 20-year-olds who died by suicide did so by firearms. The third point is that this is originally a rifle-pistol dichotomy, but rifles have really changed, are much more lethal than they used to be. So I think that's something to consider. And finally, of course, we support the background checks as the building blocks of the types of, to make sure that the prohibitions we have in this Commonwealth are fully enforced. Thank you.
Thank you.
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. For my 12th year, and you know that I support background checks. I also like the part about this bill, which gives the parity between the availability of a AR-15 as it does with a handgun, because someone between the age of 18 and 21 can do as much damage, if not more, with a long gun than they can with a handgun.
Thank you, Mr. Goddard.
Mr. Chairman, David Mitchell, General Counsel for the Richmond Police Department. The Richmond Police Department would support this bill.
Thank you.
Thank you.
Hi, good afternoon, Mr. Chairman. Kai Hunter, Vice President of the Brady Campaign to Prevent Gun Violence and retired Marine Corps Colonel. Brady Campaign is in support of this bill because we know that background checks work and saves lives. And we know that there have been 20 states and the District of Columbia that have already expanded upon the original Brady background check system. And in those instances, we see a 53% fewer law enforcement killed, 47% fewer women killed by intimate partners, and over a 50% reduction in gun trafficking. And for those reasons and everything previously stated, we are in support of this.
Thank you very much.
Good afternoon, Mr. Chairman, members. My name is Lori House. I'm with the Coalition to Stop Gun Violence, and for all the reasons expressed previous to me, I support the bill, and we support the bill. Thank you.
Thank you, Ms. Haas.
Good afternoon, Mr. Chairman. My name is Molly Voigt. I'm a state legislative manager with Giffords Courage to Fight Gun Violence, and we support the bill. Thank you.
Thank you for being here. Anybody else wish to speak in favor of the bill? All right, we'll take up those in opposition.
Yes, good afternoon. Philip Van Cleve, President of the Virginia Citizens Defense League. First of all, the senator points out that this doesn't take away guns from law-abiding citizens. Well, people 18.
Hold on a second.
Sorry.
Excuse me, I was listening to Mr. Van Cleve say this video on harming children. Sorry.
All right, I'm gonna, can we get the Capitol Police in here? Lady in the second row, you're invited to leave, ma'am. Thanks. It is aired on television. Go ahead.
Okay, sorry. Okay. So, all right. So anyhow, if you're taking guns away from 18 to 20-year-olds, those are law-abiding citizens. It does affect them. And speaking about military bases, we've had massacres on military bases. And that's sad, but the reason we had one big one in Texas is everybody was disarmed. They had to wait for security to show up. All these trained people, all these people that were so brave to put their lives on the line were being slaughtered because they were disarmed. Speaking about universal background checks, Maryland, Illinois, a lot of states have these. Just look at Illinois. They surveyed prisoners up there that were in for gun crimes. 3% went through the background check in a state that requires a background check for all guns. They got their guns on the black market from trading them for drugs. They got them from family members, a whole host of ways, but 97% of them didn't go through their universal background checks. And a straw purchase where you let somebody buy the gun for you and they go through the background check, you can't stop that. I don't care how many background checks you've got. And they set up networks to do this kind of stuff. So we oppose the bill. Thank you.
Anybody else wish to speak in opposition?
Good afternoon, Senator Obenchain.
Good afternoon.
Members, my name is Patricia Watts. I'm Commonwealth Attorney for the City of Emporia in Greensville County, here on behalf of the Virginia Association of Commonwealth Attorneys. We are opposed to it not in the merit of the case, but we think it needs an amendment, And it does, we need an amendment, so it shall not apply to the members of the state, federal, county, city, law enforcement clerks as we are transferring these items to and from. Because at this point, I think it does still include us as we're transferring it for evidence and things like that. And that's the only reason.
Thank you.
Yes, sir, thank you.
Next.
Mr. Chairman, Chris Kopacki, representing the National Rifle Association. There are two significant pieces of this legislation that we oppose: the raising of the age to 21 and the implementation of the universal background checks. Any law-abiding adult that is not a prohibited person should be able to exercise their Second Amendment rights as they do other constitutional rights. We ask men and women that are 18, 19, and 20 to protect our country through military service and be engaged in the democratic process by voting. In addition, universal background checks just don't work. There would be no way to enforce this. It creates an undue burden on people and their legally acquired property. And recent surveys that were published by the RAND Corporation also found that there's no conclusive evidence that requiring private parties to conduct background checks has any effect on homicides. Thank you.
Yes, sir.
Mr. Chairman, ladies and gentlemen, Bob Sattler, South Richmond. I didn't serve with Mr. Saslaw, but I did serve in the Army immediately after high school. And I have to admit, I'm a little miffed to think that my government would trust me with a weapon when I'm doing their dirty work, but not trust me on my own. Thank you.
Thank you. You have any closing comments?
Yeah, I got to tell you, I went in the Army at age 18, and I wouldn't have felt one bit deprived that this law required me to, that I said that I couldn't carry a gun on the outside of that military base. And he pointed, and Cleve pointed to the incident that I mentioned to you all before, and that's been the only one. And what happened was that guy, who, by the way, I think was born in Arlington, Virginia, he brought a gun on illegally onto that base and used it. But by and large, military bases are pretty secure and pretty much crime-free. So the only thing I would other ask, since got a time problem, is the people who support this bill in the audience could raise your hand.
Sure.
Well, thank you.
Yeah.
That's it.
Thank you, Senator. Any questions of the patron? All right, the bill is before us. Substitute motion. All right, there's a motion to report. Substitute motion has been made to pass the bill by indefinitely. Is there a second to the substitute motion? All right. The motion before us is motion to pass the bill by indefinitely.
Oh. Oh, wait. Oh, excuse me.
There you go. All right.
Ayes 906.
All right, the bill is passed by indefinitely. Senator, thank you for your courtesy. I do want to say, one of the things that's marked Virginia is I think that, as somebody mentioned on the floor today, is our high level of civility. I mean, we actually get along, and dirty little secret is that 95% of the issues that we work on are issues that we work on across the aisle, just trying to solve problems for Virginians. And we couldn't do that if we weren't willing to do it. But there are issues upon which there are elevated feelings. People feel strongly in this room, up here on the dais, and in the room. And I want to make sure that everybody has an opportunity to voice their opinion in one way or another, and that they're respected in voicing their opinion, whether I agree with you, whether I disagree with you. And I've certainly tried to do that as chair for people I don't agree with. And I would ask for cooperation from people in the audience as well. And the lady who I asked to leave, it wouldn't have made any difference to me which side of the debate that she was on. I just would ask that that courtesy be extended to all of the speakers. So I thank you, and certainly it's not, I'm not expressing any concerns about you or your presentation.
The second bill is deals with a device that accelerates the trigger firing mechanism.
This is
the generic
1163.
Name that came, 1163 was the use of what was called a bump stock but it's any mechanical device that is designed to increase the rate of fire on a semi-automatic rifle, but doesn't convert it to a machine gun. And it would be, it makes it unlawful to manufacture, import, sell, offer for sale, or possess that. So it's pretty straightforward. You shouldn't have something that can take a regular rifle and turn it almost, not quite, but almost into a machine gun.
Okay.
So, that's, and this one is the one that I got the impact statement from. If you report it, has to go to finance. Right.
And Senator, and I know we took this similar issue up last year, and one of the questions that was on the table was what, if anything, was ATF doing? Do you know the action?
I don't, Senator Rubin.
Charles, or do you know what ATF has done on the issue?
Mr. Chairman, the ATF has issued a regulation which will take effect in about the end of March, which would ban these devices under federal law.
Okay. And Senator Eben had a bill 1008 that was very similar that he struck, I think, partly because of the federal action. Anybody wish to speak in favor of the bill?
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. I believe that what the ATF is going to do is ban bump stocks. I don't think there's anything in there about trigger actuators such as a crank mechanism. So this bill would not be duplicative of the ATF's efforts, and we support the idea. Because one of the things about trying to survive a gun attack is the slower the bullets are coming out, the more time you're going to have to run away.
Thank you.
Mr. Chairman, Josh Horowitz, Educational Fund to Stop Gun Violence. We support the bill.
Thank you.
Mr. Chairman, Kai Hunter, Brady Center to Prevent Gun Violence, and we support the bill.
Thank you.
Lori Haas, the Coalition to Stop Gun Violence, and we support the bill.
Thank you.
Molly Voigt with Giffords, and we support the bill.
Thank you. All right. Anybody wish to speak in opposition to the bill?
Philip Van Cleve, VCDL. Yeah, we oppose the bill.
Thank you. Yes, sir.
Mr. Chairman, Chris Kopacki, representing the National Rifle Association. This bill has a little bit of broader language, a little bit more overreaching than the actual ATF proposal. And it would ban a lot of common modifications that people use sometimes, such as competition triggers and other things that may help an individual overcome disability. And for those reasons, we oppose this.
All right. Thank you.
Mr. Chairman, ladies and gentlemen, Bob Sadler, South Richmond. If I might pose an eminently practical concern, the federal ban we've discussed is already under a court challenge. Wouldn't it be a matter of fiscal stewardship to allow that to take its course and shake out on the Fed's dime? And there'll always be an opportunity to bring it back. Thank you.
Thank you very much. All right. The bill is before us. Senator Sasslaw, you have anything else you'd like to say?
I don't see why this device should be in the hands of individuals, and I don't know of many people who I've never heard, seen, and maybe the gentleman has, somebody who's disabled who needs something to accelerate the firing mechanism. If it is reported out of here, it does have to go to finance.
And I think last year, a similar bill did report out of this committee with a pretty overwhelming majority, was sent to finance.
Okay.
And so, Senator Deeds, did you make that motion?
Motion to, yes.
To report and re-refer to Committee on Finance. Is there a second?
Second.
All right, vote's open.
Thank you, Mr. Chairman.
Ayes 906.
I did? Oh. Okay. Yeah, thank you. Not looking at my cheat sheet. All right, who do we have? Senator Black is here. Is that it? Senator Black.
Thank you, Mr. Chairman.
Do we, and did I understand, Senate Bill 1024, is that
Yes.
your only bill?
No, I actually have two. I have,
Well, 1024 is going to go by for the day. So
Okay.
you have another bill?
I do. I have Senate Bill 1158, which is constitutional carry.
Okay.
The bill, I think all of you have heard the gist of the bill previously. It is grounded on the notion that Second Amendment gives us the right to keep and bear arms, and that that should not be encumbered. What it does say is that essentially, for the sole purpose of carrying a concealed handgun, a resident can carry concealed handgun in a place where he may lawfully carry a handgun openly within the Commonwealth. And it says basically that he will not be required to require or to meet the requirements of getting a permit. However, he has to be someone who is lawfully authorized. In other words, probably the biggest block of people who are prohibited from concealed carry are felons, and they would not be authorized to carry under constitutional carry if they had that disability. But other than that, it would allow individuals to carry without the necessity of a permit. We wouldn't be the only state. I know that Vermont has been doing this for quite some time without any difficulties. And so that essentially is the bill, Mr. Chairman.
All right, Senator Black, thank you very much. You have people who'd like to speak in favor of your bill?
Yes, sir.
Hi, Philip Van Cleve, VCDL. Yes, and 13 states now are doing this, and all of them have been doing it successfully. Many have been doing it for many years. Never had anyone repeal this. It works well. Basically, it's a constitutional right. And if you think about it, all a concealed carry permit is really permission to wear a coat. I can have the exact same gun on, exact same everything, but if I put on a coat and now I got to do, the background check, now I got to do training, I got to do all these roadblocks merely to put on a coat. And like I say, this works wherever it's been tried. More and more states are going this way. And we would hope that Virginia would be joining the ranks of those states that honor the Constitution that way. Thank you.
Thank you. Anybody else in favor? All right, in opposition?
So, Mr. Chairman.
Hang on. I think there's some people who'd like to
Oh,
voice a contrary view.
I apologize. I'm amazed that there is opposition to this bill.
I know.
Mr. Chairman, Brian Moran, Secretary of Public Safety and Homeland Security. And as in years past, and speaking to Senator Black, he's persistent with bringing this legislation. Just want to inform him we strongly oppose the legislation.
Thank you, Mr. Secretary.
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. This is being sold as a total misnomer. The Constitution doesn't say anything about your ability to carry a weapon concealed. So calling it constitutionally protected carry or constitutional carry has got nothing to do with the Constitution. This is permitless carry. The ability to carry a weapon concealed is a privilege which is granted by permit, and it should remain so. Thank you.
Thank you. Yes, sir.
Josh Horowitz, Educational Fund to Stop Gun Violence. Thank you, Mr. Chairman. I want to echo Mr. Goddard's remarks in that there is no constitutional right to carry a firearm concealed without a permit.
Okay. Thank you.
Mr. Chairman, Kylan Hunter, Brady Center, for all the reasons already stated, and the fact that as a United States Marine, I was charged with the life and death power of a gun and had to use it in anger and combat to protect my fellow Marines. And yet, even with the training that we go through, there are still unintentional shootings that occur from those that are carrying weapons on their person at all the time. There is friendly fire incidents that occur from those that are carrying weapons on their person all the time. What a bill like this would do would open up the general public, a place that is not a war zone, to those same risks. As has been stated, concealed carry is not a constitutional right. It is a privilege. And it is a privilege that we as stewards of our citizen, of our community, need to take more seriously. So we oppose this bill.
Thank you.
Mr. Chairman, Molly Voigt with Giffords, and we oppose the bill.
Thank you.
Mr. Chairman, David Mitchell, General Counsel for RPD. We also oppose the bill.
Thank you.
Thank you.
Hi, I'm Kristen Martin. As a mom, a gun owner, and a member of Moms Demand Action, I oppose this bill.
Thank you for being here.
Good afternoon, Lori Haas with the Coalition to Stop Gun Violence. We oppose the bill. I think that law enforcement deserves some consideration with regard to encounters with persons on the street, and their responses and reactions are driven by what they do know and what they don't know. And persons with a concealed handgun permit give law enforcement a comfort, i.e. they've been permitted, they understand that they're carrying legally, they understand that they're responsible gun owners and have gone through the permitting process. So it just gives law enforcement an opportunity to differentiate between who's carrying legally and with a permit and who may or may not be carrying legally. Thank you.
Thank you.
Good afternoon, Mr. Chairman, members of the committee. Shannon Taylor, Commonwealth Attorney, speaking only as the Commonwealth Attorney for Henrico County and not for any other prosecutor. Ms. Haas has actually commented on some of the concerns that I have. I believe that if we don't go through if we take away the proper procedure that allows a matter to be vetted before a circuit court judge that has a judicial authority to make the determination whether or not someone actually is meeting the criteria for something that is a privilege, that we would want to keep that in play. Also, this is information that is inputted into state police and does allow law enforcement to know who is a concealed weapon permit and who is not. So for the public safety of our law enforcement officers, I ask you to oppose the bill.
Thank you. Sir Black, you want to close?
Yes, I would. First, I would point to the fact that we've got 13 other states. There are no problems that have arisen from that. And I would, I understand that there may be a dispute over this, but the idea that somehow there is not a constitutional right to carry without a permit, I think is somewhat like saying that there is a constitutional right to free speech, but only if it is subject to a permit of the government. I don't think that the permit, I can understand people saying there are variations of how you view these things, but to say that the permit is somehow a part of a constitutional requirement, no difference between that and saying if you're going to speak, you have to have a permit from the government to do that. So those would be my comments.
Thank you very much. The bill's before us.
Mr. Chairman.
Sir, indeed.
I move to pass the bill by indefinitely.
All right, there's motion to pass the bill by indefinitely. Senator Peak, substitute motion? I'm sorry? All right, the substitute motion is to report and re-refer to the Committee on Finance, right? Right? All right. Roll is open.
Ayes 9, noes 5.
He may have left. He didn't leave a proxy. Huh? All right. The bill is reported and re-referred to the Committee on Finance.
Thank you, Mr. Chairman.
All right. Next, we have Senator Marsden. 1084.
Thank you, Mr. Chairman. Senate Bill 1084.
Go ahead.
Okay, thank you. This legislation creates civil liability for firearms owners who do not secure their weapons against theft or unauthorized possession if that gun is used in the commission of a crime or event resulting in injury or death. The standard of proof here is clear and convincing evidence, which of course is the highest standard that there is. What we're trying to do here is create an ordinary standard of care for these weapons. And interestingly enough, I introduced something similar to this years ago, and Senator Stewart had made an observation that suppose I was on a hunting trip and I left my gun on the porch because it was wet and I didn't take it inside. You know, the bill I had at the time, that would have been an issue. But the standard of care on a hunting trip would be different than somebody's standard of care in their home. Their standard of care might be different in a judge's eyes if an underage child was present in the home. So this allows the courts to interpret the degree to which care was taken. And the best data that we have suggests that in numerous offenses involving firearms where individuals are hurt do not legally possess those firearms. They all start out legal. They really do. In most states, firearms start out legal. What happens? How do they fall into the wrong hands? You know, people, when they, I've asked folks when they come by from the Citizens Defense League, what's going to happen to your gun when you pass away? Where's it going to go? It says, well, my children will get it. Well, what are they going to do with it? We're not sure. We don't know. Eventually, guns can fall into the wrong hands. Mostly they don't. Very few firearms are ever involved in a legal offense. But certainly we know that it results in a great number of deaths. And that's what we're trying to do here, is to reduce the number of deaths in these situations. And so that is essentially how the bill operates. It would basically leave it up to the courts to determine in a civil action whether you exercise the ordinary standard of care required of that weapon given the circumstances of where that weapon was misappropriated by someone. And very clearly that is what the bill does. And
can I ask you a question or two? First of all, paragraph A of the bill imposes civil liability in the event that the owner has failed to reasonably secure the firearm from theft or unauthorized possession. How would you envision somebody being held liable for failure to ensure unauthorized possession?
You know,
what does that mean?
If in fact you had a felon in the house, your child was a felon, and you allowed him to have possession of that weapon,
so
that would certainly...
even if it was locked up and you had a felon in the house, that would impose liability because it came into unauthorized possession?
I would say, Mr. Chairman, that in that circumstance, you have already exercised an ordinary standard of care by locking the weapon up. You know,
how about, do you have any concern that the standard, and I know you say this provides a standard, but that the standard is going to vary depending upon where in Virginia this may be?
I would say not so much where, Mr. Chairman, but under what circumstances the gun was being operated. I think there's a different standard of care. If you were going to the shooting range and you had the gun, you know, in your car with your child, you were going shooting, the gun's available. You know, it's known that when you go to the shooting range, you're going to have that, you know, that gun in an unlocked situation. Well, you're going to be carrying it into the facility. So judges would determine that based on how the gun was, under what circumstances the gun was.
And I suspect that where you live in Fairfax and where Senator Chafin lives down in Russell County, I mean, first of all, I don't think there are many shooting ranges in Russell County. Mm-hmm. And it may be that people in Russell County may have one standard for reasonably securing a gun, and people in Fairfax may have another. I mean, and I think there are a lot of people who don't lock their houses in rural areas of the state. Some who, you know, would never
Mr. Chairman,
dream
and certainly that would be up to a judge to determine. I had a case when I was running our juvenile detention center in Fairfax of a 9-year-old boy The second time he took his dad's AK-47 onto a Metro bus, we had to detain the child because the father, the Commonwealth attorney, told us there was nothing he could do. And when I spoke to the father, the message I received was, I'll leave my GD gun on my GD coffee table if I GD feel like it, and if he takes it and uses it, it's his GD fault. That was the circumstance. I couldn't believe that there was nothing criminal in that, but I don't believe that that's an ordinary standard of care to leave that weapon on there. One other quick story. 16-year-old boy, I did a transfer hearing on him. He had an IQ of 80. He was being horribly teased by 3 individuals at school. One of them carried nunchucks. They challenged him to a fight. He kept denying. He kept saying, I'm not going to fight you. And one day he said, I'll do it. And he said, but you have those nunchucks. They said, well, you can go get a weapon. He said, I'll get a baseball bat. He went home. He laid down on the bed sweating because he was in a horrible circumstance. His sister came in. He explained to her. And she said, you're not going to get Dad's gun, are you? His dad passed away 8 years earlier. There was a .45 automatic brought home from World War II in the house. He took the gun, went to the place, got out of the car, and shot the boy who had the nunchucks. A real tragedy. But there you have it. There was no standard of care for that weapon in that home.
So,
Senator Peterson.
So, Senator Marsden, in the situation you just described, your bill would mean that the victim could then sue the widow? I mean, you're enabling a lawsuit.
This is correct, and if the owner of that weapon, if that was determined to be the mother, then she would be held liable for a standard of care.
So the mother, who had no idea what her son did, is now liable for probably a multi-million-dollar lawsuit.
Mr. Chairman, Mr. Senator Peterson, I would say that the mother had an obligation to know that gun was in the house and that it needed to be that it needed to be handled with an ordinary standard of care.
Mr. Chairman. Mr. Chair, over here.
Okay, so you finished, Senator Peterson. Senator Reeves.
This is just a question for maybe Senator Peterson or yourself, Mr. Chair, but as a police officer, I worked a lot of vehicle crashes, okay? Those vehicles that were crashed were typically stolen vehicles or unauthorized used vehicles, and my question is, who is liable? Now, I understand they have insurance on them, but who would be civilly liable for an unauthorized use or a stolen vehicle that caused the death of an individual in the commission of a crime?
Maybe counsel can answer that question.
May I answer that?
Senator Peterson, please.
I would argue that there would be what's called an intervening cause. That any time you have the theft of property, that's an intervening cause that would cut off liability. I had this happen where my car was stolen a few years ago and driven around Richmond. So, and if it had been used in the commission of a crime, maybe I would have been liable if this was extended to automobiles and not weapons. But as the current civil liability is now, there would be what's considered an intervening cause.
Thank you, Mr. Chairman.
Mr. Chairman, put a different way, we have a longstanding policy in this state of not creating civil liability for the criminal conduct of another person. And that is precisely why, for example, we don't punish bartenders who overserve a patron who then gets in their car, drives drunk, and kills somebody. Not because they may not have been negligent in overserving, just as in the patrons examples, but because it's a fundamental policy decision of Virginia that we don't impose liability for somebody else's criminal conduct.
All right, let's hear from anybody who wishes to speak in favor of this bill.
In essence, in the interest of time, I would just ask that we have the members of the audience show their support for the bill by raising their hand rather than
that'd be great.
testifying.
All right, thank you very much. Anybody wish to speak in opposition to the bill or, okay. I'd ask you to be brief.
Yes, sir. Chris Kopak again with the NRA. We strongly oppose this bill. The bill seeks to re-victimize victims of firearm theft. And as previously mentioned here in the discussion, there is significant opportunity for abuse with this legislation, and it does go and attack the long-established tort principle where an intervening criminal act would normally break the chain of causation. Thank you, sir.
Thank you. Yes, sir.
Philip Van Cleve, VCDL. I think your statement was probably one of the best, the fact that there is no real standard out there. So how could a court really determine, how could a person be comfortable that a court would agree that they have reasonably secured their firearm? Thank you.
Thank you.
Mr. Chairman, I'd like to ask the patient, you would still have to show proximate cause between the carelessness of the owner and somebody getting injured.
And I would assume very strongly, Senator Edwards, that would be the case. As a non-lawyer, I obviously don't go into courts, but in that case, yes, I would think that would be the obvious.
And in the case of a crime, it wouldn't apply. It'd have to be a reckless. In other words, somebody didn't secure the guns and some child picked it up and shot another child or something like that. That's the category you're talking about, right?
This version includes crimes. If you'd like to make a motion to remove crimes from it and put negligent activity.
I move to amend it to exclude the criminal conduct. I don't have the bill in front of me, but if you can fix it that way, it'd be a good idea.
Well, that might be for another year. I think I know where this is going.
All right. Anybody else wish to speak? Yes, sir.
Mr. Chairman, members of the committee, Kevin Carroll, Fraternal Order of Police of Virginia. It would only take one time for this to happen for every single person that a law enforcement officer has to now go and investigate it, and they're going to say, it was locked in my safe. I don't know how I got out of the house. And I also think it would be disproportionate to poor people who couldn't afford to buy a safe. So if you're rich and you got a safe, or if you have enough money to buy a safe and you secure it that way, you're okay. But if you don't have a safe and you don't secure it that way, well, then you're not. So I think it needs some more work. Thank you.
Mr. Chairman, if I could, one last comment is that with this establishment of case law, we would not be in a situation in the legislature of having to imagine every possible event or every possible situation. That's the nature of civil law, is it's always presented with new situations that they have to make decisions about. And keeping this out of criminal penalties, the beauty of this is it has a real chance of changing behavior. People are going to, a lot of gun laws are just going to be ignored, but this one has substantial risk for people who do not establish ordinary care for their weapons. And I think that they will exercise greater care as a result of this, and lives will be saved.
A lot of lawyers will be happy. So, all right, bill is before us. Is there a motion? All right, there's motion properly seconded to pass bill by indefinitely. All right.
Thank you,
Chair. Those four. All right. Thank you very much, Senator Marsden. Next, we have Senator Barker is next one here on the sign-up list.
Thank you, Mr. Chair, members of the committee. I have Senate Bill 1458, which is the Emergency Risk Protection Order Bill. It's a bill that I've carried in previous years. There are, however, certainly some differences in terms of what's been happening in the past year as it relates to this particular bill. This particular bill is a bill that has been adopted now in 13 states. A year ago, it was 5 states that had adopted this measure, and has received substantial support from a broad cross-section of political and official leaders across the country. One of the things that has led to the increase has been information from those states that have employed this in terms of its effect in saving lives, that it does specifically target those people who are at substantial immediate risk to harm themselves or others, harm or kill themselves or others, and it is directed at taking action that does not affect a broad cross-section of people, but a very limited and specifically individual numbers of people that do pose significant risks that are there. It does not affect gun ownership, either by type of gun or even individual owners of guns. It does not require that a person loses liberty, either being imprisoned or held on a temporary detention order, but would deal with removing the gun on a temporary basis. It provides a basis for the judicial system to be able to take action to remove it, but it limits those who can go to the judicial system to just law enforcement officers and the Commonwealth's Attorney's Office, so it does not allow an individual to go. It also does provide a penalty that if an individual makes a statement to a law enforcement officer or Commonwealth's attorney to get them to go seek this order and does it on a not good faith basis, that individual is subject to a Class 1 misdemeanor charge against them at that point. So there is some protection written in there as it relates to your neighbor wanting to get back at you, for something in a particular situation there. One of the things that has happened in the past year is that we've had more than a doubling of the number of states that have these types of laws on the books. There are 8 additional states just within the past year that have passed this, and strikingly, it's been done on a much more bipartisan basis than many of the other types of initiatives that have been taken here, with many of those 8 states having either Republican governors or Republican legislative bodies that have passed these. It certainly got a lot of attention after the Parkland shootings down in Florida, and it was a Republican governor and a Republican House and a Republican Senate that passed this at that time. It's also been subject to study by a presidential commission set up by President Trump with leadership from Vice President Pence, who has been a very strong supporter of this legislation. And that commission did recommend, has recommended that this be adopted across the country, so that in its final report, it did make specific recommendation on that. Part of the reason that Vice President Trump has been a strong supporter of this particular approach on things was what led to Indiana, his home state, where he was governor prior to being elected vice president, of a situation that led to them enacting that. In the city of Indianapolis, which is state capital and the largest city in Indiana, what you had was an individual who directly went to police and said that he was very upset at police and that he was going to kill police officers. In that particular situation, the police officers went to their superiors, who went to the judicial officials, et cetera, to determine, what can we do in this situation to try to prevent this from happening. The response that was given, there's nothing on the books that will allow us to do anything to prevent this. So therefore, we are not in a position to be able to do anything to this individual until and unless he acts on it. In that situation, he did follow through with his threat and killed a police officer. And so that was, the part of the genesis for this, and part of the reason that Vice President Pence and a number of other officials in Indiana have taken strong positions in favor of this legislation. There have been some questions raised, and I talked with the chairman earlier today with some of the process things in here and some suggestions from the Supreme Court for some changes that would improve that process. If there appears to be some willingness to look at those, I could deal with that over the next, between now and sometime next week, whether it be Monday or Wednesday. But I'm happy with whatever you decide in terms of the process.
And Senator Barker, I thank you for raising that issue with me earlier. And I think we've got a pretty good idea as to what the policy issue is. If this bill reports, it's got to go to the Committee on Finance, so there will be an opportunity to massage the bill and address any concerns the Supreme Court may have had or expressed. So with that, does any member of the committee have any questions of Senator Barker? Senator McDougall.
Senator Barker, what is the standard difference? Right now, if somebody possesses a threat to themselves or others, you can go through a TDO or temporary detention order process. And we have determined previously by statutes that some of us patroned historically that if you have been subject to a TDO or a voluntary or involuntary detention, then you are not legally able to possess a firearm. So what's the standard difference for this than what the current law is?
The standard difference here is that to be able to get a TDO, you have to demonstrate that someone has some type of mental illness, some type of behavioral issue that is leading to this. So in this particular situation, this would then deal with people who maybe it's a simple case of anger, it's type of something that they're just looking to get back at somebody, but there is not a diagnosable mental illness there. And so they would not necessarily be subject to a TDO, but could be subject to this.
Senator McDougal.
Mr. Chairman, I didn't think with the TDO that there had to be a determination of mental illness. You have to be a danger to yourself or others. It doesn't necessarily have to be because of a specific mental illness. So I don't think that's an accurate statement. So that's why I'm trying to figure out what is the legal difference between what you're describing and what the current law is today?
Yeah. Well, what I can tell you is that having sat through, through the Deeds Commission on a number of things where we've looked at these types of things there and listened to testimony across the Commonwealth, that clearly in many instances a temporary detention order has not been issued for someone who has a situation where they are seen as posing some risk, but there's not an identifiable mental illness that leads to that. So that's been sort of the practice and the way things have been implemented across the Commonwealth in many instances.
Charles.
Mr. Chairman, to answer Senator McDougal's question, the emergency custody order provisions do provide that any magistrate shall issue upon sworn petition of any responsible person, treating physician, or upon his own motion, an emergency custody order where he is probable to believe that any person has a mental illness and there exists a substantial likelihood as a result of mental illness, the person will in the near future, and then it is the cause serious harm or suffer serious harm to his lack of capacity. So mental illness is one of the requirements.
Right. Not a TDO.
For
an emergency custody order which precedes a TDO.
Right, yes.
Okay.
The emergency custody order is what can be issued for up to 8 hours and before a determination is made whether you need a temporary
Anybody
detention
have
order.
any other questions of the patron? Senator Stewart.
Thank you,
Yes.
Mr. Chairman. Senator Barker, and I'm sorry I came in late, and if I missed something, I apologize. But if I read this correctly, this actually allows the police or someone to enter a person's home, their private home, and potentially seize their property without actually affording them any due process whatsoever. Do I misread that?
My understanding is that that would follow the action that was taken by a judicial official, and so a court official. And so that would be done at that time to be able to remove the
Senator Stewart.
I mean, based on a bare allegation that it needed to be done, someone could go into someone's home, seize their property, and they were not afforded due process yet.
No, well, they would, it's not simply an allegation. It has to be done by, an individual cannot sort of go to court and get this action. You have to have either a law enforcement officer or a Commonwealth Attorney's Office who initiates going to a judicial official and getting
But due
that
process.
decision. Due process, yeah.
Steve, you are maybe more equipped to address this, but doesn't due process involve notice and an opportunity to be heard? Isn't that what due process requires?
Yes.
Maybe even confront
Those are components of due process. What is required depends upon the circumstances. So right now, we're talking about two different things. One is the degree of due process, Mr. Chairman, necessary for the issuance of the order, which, as I understand it, lasts for 14 days and requires that person to relinquish his firearms to the agency that serves the order. That's step number one. But what Senator Stewart was asking about is step number two. If an officer develops probable cause, that is reason to believe that a person who's a subject of one of these orders is in possession of firearms, then a search warrant will be issued ordering the officer to enter the home of that person to seize any firearms that are still in their possession. The problem with that is, and no search warrant requires an opportunity to be heard. If an officer develops probable cause and in an ex parte showing satisfies a magistrate that there's probable cause to believe that a crime has been committed and that evidence of that crime or contraband exists in a house, then a search warrant can issue. The problem here is that it does not require a finding that any crime has occurred or is being committed. Simply that somebody believes that a firearm is within the home of somebody who's no longer permitted to possess it not because of criminal activity, but because of this substantial risk order. The harm is not only the entry into somebody's private home who has not committed a crime, it is that once that law enforcement officer is within the home, they then have all the rights and responsibilities that attend their being in the home pursuant to a criminal search warrant. So if they enter the home for the laudable purpose of enforcing the order and ensuring that this individual doesn't possess guns, if they see any evidence of any other type of crime, they are lawfully permitted to seize that evidence and initiate a criminal prosecution. And so this is, unfortunately, what this does is circumvent the protections that are built into search warrants. So Senator Stewart has identified a problem indeed.
And, Mr. Chairman,
Senator Stewart.
and thus does that not violate the Constitution?
I'm not a constitutional expert to consider that, but.
I think it does,
so,
Senator Barker.
I think that was a rhetorical question. Senator Sturtevant.
Thank you, Mr. Chairman. So what I'm hearing from council and others is that there is a temporary detention order requires showing of a mental illness for issuance.
Right.
And
Mr. Chairman, no, there is not a requirement of mental illness. Mental illness would be for the regular emergency custody orders under Title 37.2. This does not require a showing of mental illness. This just is merely a probable cause to believe a person possesses a substantial risk of personal injury to himself or others in the near future by such person's possession or acquisition of a firearm. So it is not linked to mental illness.
Right, but the current law on the books requires the showing of a mental illness.
Yes, for an ECO or a preliminary detention order, then yes, it would be.
So, Mr. Chairman, Senator Parker's bill is attempting to address situations where there may not be a diagnosable mental illness, but there may be a substantial risk of harm that someone could pose to themselves or others.
That's correct.
As I understand it. So there is a gap that is attempting to be addressed.
Right. Mr. Chairman, that's correct.
Which I think is laudable and important. The second issue is the constitutional issue that Mr. Benjamin raised, and my question to him would be, is there a way, and I know this is putting you on the spot and asking a lot, but is there a way in which that important Fourth Amendment constitutional issue can be addressed?
Sure.
That also addresses this gap.
Mr. Chairman, you are right that this is a practical problem. And thinking on the fly, one solution would be this. The bill as it's written currently requires that the order notify the subject that they are to relinquish their firearms to the officer who is serving the order. If we left it at that, and then, and look, I'm not in the business of writing new criminal offenses, but if the bill included a criminal offense, if it were unlawful, for example, for a person to knowingly possess or purchase a firearm after being ordered not to, and while the order is in effect, and if it were penalized as a misdemeanor, it could even be a Class 3 or Class 4 misdemeanor. You then have a distinct criminal offense. And if a law enforcement officer developed probable cause that a person was in violation of this criminal offense, then the conventional rules kick in. They can go seek a search warrant in order to seize contraband or evidence of a criminal offense. But again, my caution is I'm thinking on the fly.
Sure.
Mr. Chairman? Mr. Chairman?
Senator Edwards.
It sounds like this ought to go back for a week anyway to look at it, because I don't know how you would apply this. What it says is there's substantial cause to believe that a person is a danger to themselves or others by virtue of having a gun. And there's no mental illness mentioned. There's nothing, I mean, are they acting crazy? I mean, if they threaten somebody, that could be a crime.
Yeah,
But,
for example, in the situation that was encountered in Indianapolis, what you had was an individual who was not mentally ill, judged to be mentally, assessed to be and diagnosed to be mentally ill, but made a direct threat that he was going to do.
Well, that's the difference. Yeah,
And
maybe
so-
that needs to be written into this statute. Some kind of action. They're a danger to themselves or others because of what? By virtue of, and they shouldn't be around
Well,
guns.
probable cause is the language that's used in here in terms of what.
But what
standard-
conduct are they doing that makes them a magistrate to think that they are a danger to themselves or others? That's what's missing here, as far as I can tell.
Okay.
That's why I think it'll be put it off for a week and sit down. I'll be glad to work on it myself.
Senator Edwards, I'm just sort of stepped into the role here of chairman, and I'm not sure that the chairman wants anything going by because we have so much to do in such a short period of time. If Mr. Benjamin can help now, that's one thing, but I don't think we're going to carry this by for a week.
I think I can help, Mr. Chairman. Charles pointed out that on page 2 of the bill, that is lines 91 through 100, the
Right.
bill already creates a
Correct.
new criminal offense.
Right.
I just missed it, sorry.
Okay, that's all right.
And so the solution here for the problem that you raised, Mr. Chairman, would be on line 515, after the word firearm, strike the words, the phrase that begins "that," down to line 516 that ends with the word "section," so that it reads, advising such person to surrender any firearm to the law enforcement agency that served the order. Okay, that's 515 to 516. Strike that has not been taken into custody pursuant to a warrant issued pursuant to this section. We're going to strike that, is a possible solution, because we would then strike subsection E, 549 through 567. That is that weird little warrant provision that gave us concern.
Right.
And so that appears to be the immediate answer that I can give you to that situation. You already have a criminal offense, and if the order is issued and a law enforcement officer has reason to believe that the person is possessing a firearm in violation of that order, they can go to a magistrate and get a regular search warrant.
Search warrants, okay.
If they've committed a criminal offense and they believe they are possessing a firearm.
Yeah, and this creates a criminal offense for the continued possession of the firearm.
Okay.
That's on page 2.
I see what you mean.
Remove that amendment and
And
concept
other
or
line.
something.
There's a motion and a second on that amendment. Is there any discussion?
The motion.
Everybody understand it?
The motion should include lines 425 through 431. In other words, any line, any language that deals with this warrant that we're removing from the bill.
All right, so
Yes.
that sounds reasonable to me. I would certainly be happy to have that amendment made.
So what are you left with, Mr. Benjamin?
You're left with what I think is the essential
intent- the
aspect of the
intent
bill.
of
That
the
is
bill.
the opportunity to get a substantial risk order
Right.
to order the individual to relinquish their firearms. The order lasts 14 days.
Up to 14
I
days,
think there's subsequently an opportunity to be heard.
Yeah, within 14 days, you have to go to a circuit
Right.
court judge.
So,
and
so
circuit
the
court
bill
judge has to
does,
hear it.
I think, what the patron mostly intends for the bill to do. We have removed
The magistrates earlier. Yeah,
we have removed the opportunity for a quasi-search warrant.
right,
We're protecting the privacy of the home, in other words.
right.
All right, there is a motion with a second to adopt the amendments as described by Mr. Benjamin. Is there discussion or questions on those amendments? Anybody? Would you go through those again, please, Mr. Benjamin?
Sure. what we are doing on,
515,
right, on line 515, we're striking the words, the phrase that begins with the word "that" after firearm, down to the word "section" on line 516. Strike that language. And that language is referring to, drop down, subsection E that begins at 549 through 567.
right.
Similarly, and we're striking that because that's the section that establishes a semi-search warrant where there's no criminal activity. And then, Charles, where was the other? 425 through 431 is struck. And those are the only amendments.
Right.
425 through 431.
And 494?
The only other amendments would be reordering the paragraphs.
Okay, and 494 through 497.
Right.
And so, at the end of the day, you're left with the opportunity to go before court.
Or magistrate.
Or magistrate.
Well,
Mr. Chair.
And get an order to force them to relinquish their firearms because of their mental state or something like that. Which, if they violated that, would then be a crime.
Correct.
And you could then, but still get a
Search warrant
to go into their home.
Yes.
But they have been afforded some due process.
Well,
Or
they've
have
been
they-
afforded no more due process than any citizen has when a law enforcement officer seeks a search warrant. If a law enforcement officer has reason to believe that you are committing a crime and that there's evidence of that crime within your home, then they, in an ex parte proceeding, will go to a magistrate, swear out an affidavit, and get a search warrant to enter your home at any time of day or night. I mean, that's for any citizen is susceptible to that. What this does is say if you are the subject of a substantial risk order, and you've been, actually the due process is you are served, I think it's personal service.
Right.
You're personally served with an order directing you to relinquish your firearms and telling you that you are not permitted to possess a firearm for 14 days or something. And so you have notice that a court has ordered.
So, is that then a felony, Mr. Benjamin? If you violate that, does that
It's a
become-
misdemeanor, Class 1 misdemeanor.
Be a Class 1 misdemeanor.
Right.
All right, Senator Sturtevant's been waiting patiently.
Sorry?
Senator Sturtevant, yes.
Yeah, Mr. Chairman, the other things that jumped out at me were you would have to have the hearing before a circuit court judge or a magistrate?
A search warrant can be issued by a magistrate or.
Not
initial
necessarily.
hearing.
Oh, the initial hearing.
Yeah.
The initial hearing.
Charles?
Mr. Chairman, the emergency substantial risk order is done by petition by the Attorney for the Commonwealth or law enforcement officer before any judge of any court or any magistrate. What I'll refer to as the substantial risk order, the more permanent substantial risk order, has to be pursuant to the circuit court where the person of the subject of the emergency order took place. So the non-14-day order has to take place in circuit court.
And Mr. Chairman, Senator Sturtevant, I know from other bills and concerns that the reason the magistrate is included, in some jurisdictions, courts are not in session every day. And I think the patron envisions an emergency situation, and so the magistrate is included so that there is a judicial officer available when one is needed. I think that is why the patron has included magistrate.
Yeah, and for example, I mean, in previous years, I've had the requirement that just to get the initial action, it had to be before a circuit court judge, but that was part of the concern that people had about being able to get it on a timely basis there. That's part of what we've trying to work with the Supreme Court and others in terms of figuring out are there other mechanisms, because I do strongly prefer it being a judge and not a magistrate to make that so.
Mr. Chairman.
Senator Sturtevant.
I think that the patron in the past has had it before a circuit judge.
That's correct.
Circuit court judge only, as I understand it, and we have substitute circuit court judges that work every day all around the Commonwealth. I would think that that would be the most appropriate place for one of these hearings to go. And then the other thing that concerned me was having to wait 14 days. I wonder if a shorter time period of, say, 24 or 48 hours might not be a better time frame.
Well, just before we get too far afield, we've got a motion and a second on the amendments that were described by Mr. Benjamin. So let's vote on those. If you want to offer other amendments, we can then take those up. Are there any other questions or discussion on the 3 initial amendments that Mr. Benjamin suggested or offered, or highlighted, I should say? If not, then motion properly seconded to amend as described. All in favor, please say aye. 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 Opposed? Ayes have it. Are there any other? Senator Sturban, at this point, do you want to offer additional amendments?
Well, Mr. Chairman, yeah, I think, and I think that the patron just mentioned this, that as he has done previously, that initial hearing before a circuit court judge as opposed to a circuit court or a magistrate is perhaps a way to further ensure a full hearing on an important matter like this.
Okay, is that an amendment? Is that
Yes, it is.
offered amendment? Did you have any others? You suggested something else as well. Do you
Sure,
want to include
and then
it?
I understand that there has to be a, if I understand the mechanics of it, there is the initial hearing, which will now be before a circuit court judge, and then you have to have a second hearing within 14 days.
Right,
Is that correct?
within 14 days, and
Okay.
certainly, part of the discussions we've been having is sort of trying to figure out how, could we make that shorter?
Right.
Here, and how much. So we've not got that fully resolved at this point, but that's part of the discussion we're having now, because we want to make sure that we protect the individual's rights to the maximum
Sure.
extent possible here in this process.
Mr. Chairman, I would think that for an important issue like this, we would want to have that hearing within 48 hours. And so I would.
All right, so he's offered to amend the bill to restrict it to just a court of record, circuit court, and to have that hearing within 48 hours. Are those?
Yes.
You like those?
I like those, yes, because they're getting at the heart of what we want to do here.
Okay.
So.
Is there a second to that? Motion properly seconded to amend as described. Charles?
Just for clarification, so the emergency order would expire after 48 hours?
I thought he wanted to have a hearing within 48 hours.
And that's why I'm seeking clarification, because right now, the emergency order is good for 14 days. The emergency order coincides with the amount of time the other order provides, the other hearings required. So if you're doing it for 48 hours, I'm asking if the emergency order will only be as good as to the next hearing, which is 48 hours.
What's your suggestion?
I think that's appropriate.
Well, yeah. I'm fine with doing something that sort of makes the point here, and then if this goes forward, we may need to slightly expand that. If this happens on a Friday, you may need till Monday to get it, so that would be 72 hours rather than 48 hours. And that what we need to do is sort of work with the Commonwealth's attorneys and the Supreme Court to sort of figure out what is the shortest time period that we can put in place here that would actually work. So, but I'm fine with having it amended here to address that, and we could make further amendment if necessary. So
I think that's correct.
Thank you.
All right, do we understand the amendment? Does everybody understand the amendments offered by Senator Sturman? Any questions or discussion on that? Motion properly seconded to adopt those amendments. All in favor, please say aye. 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 Opposed, no? All right, the ayes have it. So any other questions of the patron up here? I'm sure there are folks who'd like to speak to this bill as amended. George, do you have people that you want to have first?
Yeah.
I think I've been advised the chairman's allowing 4 minutes on each side, so we'll stick with that time allotment.
Mr. Chairman, Brian Moran, Secretary of Public Safety and Homeland Security. First of all,
Nice
thank
to
you.
see you, Mr. Secretary.
Nice
Thanks
to be
for
here.
coming.
This is a very important piece of legislation for the administration. So first, appreciate everyone's time and attention, and Professor Benjamin over here rewriting it. And there are some issues with respect to the amendments. I just remind everyone that we have magistrates issue felony warrants for serious crimes now, whether rape, robbery, murder. I question whether or not we need to elevate it to the circuit court. For the hearing, we elevate it to the circuit court. But the initial issuance of this, that's an amendment, frankly, I don't understand why we would pursue that. But with respect to the overall policy decisions in this, I remember, we've reached our colleagues and communicated with them in Florida, Connecticut, Indiana. Florida, I remind you, one of the reasons that they pursued this legislation was because in that case, the police visited that home of the individual who ultimately committed the tragedy at the school approximately 32 times, but it never elevated to the of a criminal case where they could either arrest or enter the home. That's why Florida responded in this way, and I think that's what the direction Virginia has to go. I think there is due process with respect to this bill. It's a temporary deprivation up to 14 days, and then you have a hearing. And it's only in the cases of a substantial risk to himself or others. And himself is important. We've done a lot of work around school safety, and I commend you all. I think we're going to have some real successes this year around school safety. I remind you all, over 60%, suicide is now the second leading cause of death amongst our young people. Over 60% of those are due to gun suicide. And so, this is where the parent feels very concerned. They haven't committed a criminal act, but they go to the local law enforcement. And again, this contemplates only local law enforcement or the Commonwealth's attorney to get this warrant. This isn't neighbor to neighbor retaliation. That is not in this bill. But that parent can go to law enforcement. The law enforcement officer can go to the magistrate in an emergency situation. If there is indeed that minor has a firearm, it can be removed from the home. So this is a piece of legislation that keeps the guns out of those individuals who we do not want them to be able to possess a dangerous weapon, either in danger of themselves or others. And so this bill gets to it as a policy matter. We look forward to working throughout this process with respect to its implementation and the process in the court. But I think this is, and I'll let others speak. I know they want to speak. Governor feels so important about that. There is money in the budget, over $400,000 to create the registry for the Extreme Risk Law Registry, in addition to $50,000 in the Woodrum Amendment. So it goes to finance. There is money in the budget to finance this piece of legislation.
Thank you, Mr. Secretary. Yes, ma'am. Come on.
Good afternoon, Mr. Chairman,
Good
Committee.
afternoon.
Shannon Taylor, Commonwealth Attorney for Henrico County, speaking only as the prosecutor for Henrico and not for VACA. First, let me just point out a couple of things. I wanted to share that at least with Henrico, that we have had, to my knowledge, that I've been involved in 2 cases that could have benefited from this particular statute. As Senator McDougal pointed out, we do have the idea of a temporary detention order, the involuntary commitment aspect of it. But not only is the mental health diagnosis a part of there, but there also has to be a treatment plan that's available. And what we see is what we're talking about with families, when we talk about the stigma of mental health and what families want to do to put their loved ones through a TDO or involuntary commitment, they may not have the ability to go through that, but they may have the ability to share other concerns that may fall into what Senator Barker has identified as a limited group. I know the time has gotten all weird on me.
And I'm sorry, but because we have so much to do and so many bills,
I know,
and it's so
but
late.
I didn't even start at 4 minutes. That's why this thing has
No,
gone crazy.
I think the secretary used a lot of that time, but that's okay. He's an important guy, and we wanted to hear what he had to say.
So
if
to
you could just wrap up, because there are a lot of
identify
folks
what
who want
Senator
to speak.
McDougal pointed out, this is something else outside of that. To point to what Mr. Benjamin said, I totally agree with his constitutional fixes to this. It does set forth the appropriate time. to address Senator Sturtevant's issues about whether or not we want to go before a magistrate versus courts. We are blessed within this area that we have circuit court judges that are available. That is not true along the Commonwealth, where you have circuit court judges who do not sit as often as
Those
there.
amendments have already been adopted.
Yes, sir. And to the second point, which is this is within 14 days, and so you can be assured that people want to take these matters seriously and they will not languish. For that, we'd ask you to accept the bill.
And I'm sorry, but if everybody that would like, if you support the bill, would you just let us know you support the bill? We try to honor these because we put the constraints on both sides.
Good afternoon, Mr.
So
Chairman.
if you support the bill,
I
just step on up and say you support the bill.
My name's Theo Samos. I'm the Commonwealth Attorney for Arlington County and the City of Falls Church. I'm here in my individual capacity and also on behalf of Brian Porter, the Commonwealth Attorney for the City of Alexandria, and we heartily support the bill, recognizing the amendments that have been made very prudently. Thank you.
Thank you, Mr. Chairman. Kyle Ann Hunter, Vice President of the Brady Campaign. And I support this bill because an ERPO saved my life. And if it were not for one of these orders, I wouldn't be here today being able to testify for you.
Thank you for coming and testifying.
Hi, my name is Kelly Roscom. I'm the legal director of the Educational Fund to Stop Gun Violence. I'd have a lot more to say given a more adequate amount of time to explain a very complicated issue, clearly as it was discussed among the members of this committee. However, I'll just say that we do support this bill.
Thank you.
Josh Horowitz with the Educational Fund. I'll just, Mr. Chairman, just address one quick point that Senator McDougall brought up, and that is that recent figures show that 50% of suicides now are not related to mental illness. We need a second situation, a second order here to deal with those situations for people who are suicidal but not mentally ill. Thank you. We support the bill.
Good afternoon, Chairman and members of the committee. Thank you for the extra time. We really appreciate it. This issue is important. Families face crisis. Crisis can be for a number of reasons. People can be abusing alcohol, abusing drugs, despondent, angry, all sorts of reasons for crisis that don't rise to the diagnosis of a mental illness or a TDO or ECO or even an adjudication. Family members are asking for tools to keep their loved ones safe. This is very narrowly crafted, and with your amendments, it's even more narrow. I urge you to pass the bill. Thank you.
Thank you. Yes, ma'am.
Hi, Mr. Chairman. Molly Voigt with Giffords, and we support the bill.
Thank you.
Thank you.
Mr. Chairman, Felicia Preisner, Associate Director of Virginia Catholic Conference. Virginia Catholic Conference supports this bill.
Thank you.
Good afternoon. Sushila Varkey on behalf of Virginia Poverty Law Center, and we support the bill. Thank you.
Good afternoon, Mr. Chairman. Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. We support the bill.
Thank you.
Hi, Kristen Martin with Moms Demand Action. I support the bill because it will save lives. And to quote a Richmond City policeman of 20 years I spoke with last night, he said this allows law enforcement to be proactive instead of reactive. We need to get out in front of these things.
Thank you.
Mr. Chairman, my name is Sarah Harper, and I'm with Moms Demand Action, and we support this bill. Thank you.
Thank you. Anyone who would like to speak in opposition to the bill? And the same restrictions of 4 minutes apply.
Would we get a little bit over like they did at 4 minutes? Okay, thank you. Hopefully we won't need it. There's so much wrong with this bill, that's why I'm asking. First of all, let's be frank. It's a confiscation bill. It's not a bill about saving lives. The reason for that's simple. Let's say the person is indeed dangerous. This does nothing to the person. He's still home. He can still commit suicide. He can still murder his family if that's what they're concerned about. It does not take him out of the situation. So how does that save him from committing a crime or suicide or murder? It doesn't. He's still there. So he's not being taken off a TDO. At least you're taken somewhere, you're analyzed, maybe you get treatment. This is nothing. It's just leaving you there. And if you were suicidal or angry to begin with, this is really going to make you suicidal or angry. This does not make anybody any safer. The due process, well, it looks like that's been improved. The idea of getting it after your guns have been taken is really unacceptable. And your guns are going to be probably not taken very well care of. They're going to be thrown in a police car, and if you've got some expensive guns, this allows the police not to even be responsible if they lose your guns. In Maryland, 2/3 of the people that are requesting these are thrown out because they're frivolous. We're probably going to see the same thing here. They're being used for vengeance, getting back at an ex-spouse. You go to the police officer, you swear your ex-husband is going to kill himself. He goes in front of the magistrate, and all you get if you lie and are caught is a misdemeanor. It should be a felony if you're going to take away somebody else's civil rights for up to 14 days or even at all with a lie that you know that you're telling instead of a mere misdemeanor. This should be very serious when the police show up at your door to take your guns, and the person lied to do that. Again, there's been no crime committed here. The person has done nothing wrong. It's all on allegations. For a poor person, there's no requirement for an attorney to go in front of the judge. And so if they can't afford an attorney, they could find themselves getting into hot water because everything you say in front of that judge, if anything is wrong, can get you in trouble. So this whole thing is a farce. It's really going after confiscation. If you're for confiscation, you'll love this bill. If you're for the Constitution, you're going to hate it. Thank you.
Yes, sir.
Mr. Chairman, Chris Kopak, again representing the NRA. We've opposed this for a number of reasons, and I'll try to be brief with my 1 minute here. One, this legislation does focus solely on firearms as a means to harm oneself. There's many other additional means out there. The ex parte provisions of this bill deprive individuals of due process and this, in essence, allows the government to come and seize property without due process or even being accused of crime. Number three, and I think this is a very important component, is that there is no requirement for mental health intervention here. The idea that the police can come to your house, seize your property, tell you to behave for 14 days until they have a hearing is unreasonable. And concerning the potential now, 48-hour hearing, if I'm getting ready to prepare to come into a hearing to protect my rights, I probably need to hire a qualified and competent defense attorney, which can be expensive, and trying to find one in 48 hours or 72 hours can be extremely difficult, and the expectation that they can actually gather the evidence needed to put on my defense, I think it would be extremely difficult in this situation. Again, for those reasons, we oppose.
Yes, sir.
Bob Sadler, South Richmond. Mr. Chairman, just to touch on what Philip said, this should really give you heartburn. There is a tremendous disparity in liability here. The petitioner goes before a commonwealth's attorney or a magistrate and is completely shielded from ever going before a judge. If I want to get my property back or restore my good name, I do have to go before a judge. I put my hand up, I swear an oath, and if I so much as lie about where my car is parked, I'm on the hook for a Class 5 felony. And there are other things, but
Everybody else. If there's no discussion, questions for the patron, do you want to follow up on anything as a result of what was said?
No, I think you've had a thorough discussion of this already. I don't need to add anything at this point.
All right, then the bill's before the committee.
Mr. Chairman, this is a really important bill that we're discussing here, and there's been all these movements to try to work with the bill and to try to get the bill in some posture, but I believe that something like this needs to be looked at more in depth than us sitting here changing the nature of the bill, changing the way the bill would be processed, the procedural components of the bill, and I think that this bill ought to be studied by the Crime Commission. I think something like this is important enough for the Crime Commission to look at it. I truly appreciate Senator Barker bringing this bill and making this effort, and all those who have testified one way or the other in a passionate way about this, because it is an important subject matter that we're discussing. And we're talking about people's lives, and we all hold lives sacred. And so, but I just don't think that the bill is I don't think this is it. I don't think this bill is quite ready to go, and therefore I'm going to gently make a motion to PBI the bill.
Mr. Chairman?
You want to, let me just clarify one thing, Senator Howell, with Senator Chapin. Do you want a PBI, or do you want to carry it over for the year and ask that a letter be sent?
You can't carry it over.
You want a PBI, okay. Senator Howell?
Well, I thought he was going to recommend it go to the Crime Commission, and I wanted, instead of PBI, but what I wanted to point out is the Crime Commission at this point has no bandwidth for a couple of years, probably, to look at it, but the Deeds Commission actually has expertise in mental health issues. So if it were to go somewhere, I would think that would be the more appropriate place.
Mr. Chairman.
Senator Obenshain.
And I don't know what is on the Crime Commission agenda for next year. We haven't set it, and I think the Executive Committee of the Crime Commission is going to meet later in session to set its agenda and look at its bandwidth. So, I don't know whether the Crime Commission would do it or the Deeds Commission would do it. Maybe letters to both, and we can see if somebody can look at it.
I think that's an excellent idea, and sometimes these commissions do work together on an issue that's overlapping. That's an excellent idea.
And that would be my motion, Mr. Chairman, that it be PBI with letters from the chair of this committee to both commissions.
Is there a second? Is yours a second, Senator Howell? We have a second.
I don't want to vote to PB.
Yeah.
It's an important
I'm
issue.
trapped.
All right, there's a motion properly seconded to PBI the bill.
Mr.
and
Chair.
with a letter to the Crime Commission and the Deeds Commission. Is that Senator Peterson?
Yes, sir.
Senator Peterson.
I just wanted to speak briefly. I've been reading this bill and sort of doing some research while this whole conversation's going on. I'm an attorney, and I had a very similar situation happen with a client of mine that had a lot of mental health and substance abuse issues, and at one point his sister and I had to get into the house and take the firearms away. He had signed over a power of attorney to me, so I didn't just do it of my own volition, but he would have been a candidate for this, and he ended up taking his own life. And I say that because I think this is a situation that needs to be addressed. And I've sat on a few conference committees in my time, and I hope people think I'm fair-minded and hear from both sides. So I'd like to push this along. I think, we kick this into a conference, and we're going to come back a year later and have all the same disputes. But, so I'm going to oppose the motion to PBI. Not that I don't recommend, I understand the issues that have been raised, and they're strong issues, but I do think we need to solve it now. Thanks.
Mr. Chairman.
Senator Edwards.
Is there a motion to PBI now?
There is a motion properly seconded to PBI with letters to both commissions to have it studied.
Let me say, I agree with Senator Peterson. Having looked at this, and this has been an issue that's out there, I think we can resolve it in the course of this session. Get it through, I guess it's got to go to finance, and then it'll end up going to the floor, maybe go to the House. We can work on it in conference. I've seen a lot of good work done in conference. I don't think it needs to be PBI because I know what the Crime Commission is going to do, which is probably nothing. And so I'm opposed to PBI in the bill.
Mr. Chairman.
If there's Senator Obenshain.
Let me just say, and I don't know whether Senator Barker knows whether there's a House companion to this, and
Yes,
the
there
Secretary
is a House
indicates that
companion
there
to this,
is. Just being a bit of a realist, I have an idea that if this goes down to the House, that it may not find its way back. And if we have an opportunity to ask somebody to look at this, I think this is it. If we send this bill along, it may not, we may never see it again or have an opportunity to convey that in the House bill. If it comes over, wonders may never cease, but, we may have an opportunity to act on the policy issue, but I think it is an important issue. I agree with Senator Chapin and Senator Howell, and I think this is our opportunity to get subject matter experts working on some of the issues that have been identified. And, if we wind up, if this has an opportunity to pass, we're going to have another opportunity to look at it. But right now, we've got a chance to, ask subject matter experts to work on it, and I think that's a good idea.
Okay. No other discussion. The motion is before us. Clerk, call the roll.
get me. I got you.
No to PBI.
Ayes 7, no 7.
So it fails to do anything.
I move to report the bill as amended.
All right, there's a motion to report the motion, there's a motion to report the bill. We'll reverse the roll.
And refer to finance, I presume.
Report and re-refer to finance. So let's go ahead and open the vote. This is to report.
Ayes 7, no 7.
All right, the bill fails to report. 7 to 7.
We can bring it back next week. We can bring it back next week.
The bill remains in the breast of the committee, but in order to, I mean, you know the drill, to move to report, there has to be a motion to reconsider. Okay?
Thank you.
All right, Senator Barker, thank you. Next, we have Senator McClellan.
Thank you, Mr. Chairman. I have Senate Bill 1324. This is a bill you have seen before. Last year, at the request of the City of Richmond Police Chief Alfred Durham, we introduced, the Richmond delegation introduced legislation to require that lost or stolen firearms, excluding antiques, be reported to local law enforcement or state police within 24 hours. The reason he requested this is because lost and stolen guns pose a significant risk to the community, and the lack of mandatory reporting enables gun trafficking and straw purchases by eliminating accountability and allowing individuals whose guns end up used in connection with a crime to simply say that their gun was lost or stolen, which thwarts the ability of law enforcement officers to solve these violent crimes. Since last session, I was contacted by a constituent, Letitia Sessions, who is here. She asked me to tell her son's story because it's a little too emotional for her, but I did want to at least have her stand and wave.
Sure. Thank you very much for being here. I appreciate it. Thank you.
So Letitia's son, Kevante, was a senior on the verge of graduating from high school here in the 9th District. He was shot and killed in 2017 on his way home from a convenience store just blocks away from his house. Kevante's mother, Letitia, shared that he was a honor roll student, an AB student. He was an athlete, he was creative, he was fun-loving, and always tried to find a positive position even in the face of negativity. Before his death, he was planning to go to college with an interest in becoming an electrician. After Kevante was killed, Letitia found social media pages of some of his peers touting guns and piles of cash. Kevante's murder remains unsolved, but there is a concern that he was killed by an illegal firearm in the possession of one of his peers. At this time, Kevante's mother continues to work with investigators to solve the murder of her son. And although there is no proof that the gun used to take Kevante's life was lost or stolen, we do suspect that it was. And we do know that reporting lost or stolen firearms aids law enforcement during their investigation. And so Letitia asked me to put this bill back in, as did the City of Richmond Police Department. And I have here David Mitchell, who is the General Counsel of the Police Department, who is here to testify and answer any questions. But I do want to give you a few statistics. Researchers from Harvard University estimate that 380 guns are stolen in the United States every year, yet only 240 gun thefts were reported to the FBI in 2016. Local police have taken 5,873 reports of firearm thefts in the region from 2009 to 2017, and many involved multiple weapons. But again, we know that there are more lost and stolen firearms than what are reported. 4 localities in this region experienced a staggering jump of 62% in firearm thefts during this 8-year period, with thefts from vehicles alone spiking at 2004%. Again, these are just the numbers that are reported. I don't think I need to tell you that part of the issue with lost and stolen firearms, being out in the world with no way to track them, makes it very difficult when they are used in a crime to trace the chain of custody. And so this bill is also designed to help with that. But again, I'd like to ask David Mitchell to come and explain a little bit more why the city of Richmond feels that this is an important issue, important enough to bring back again before this committee.
Yeah, Senator McDougall, do you have a question? All right. More than happy to hear from witnesses who wish to speak in favor of the bill.
Mr. Chairman, David Mitchell, General Counsel for the Richmond Police Department, here on behalf of Interim Chief Smith, who couldn't make it today. And I will say Senator McClellan pretty much nailed it. We'd first like to clarify that this is not in any way meant to infringe upon someone's right to own a weapon. And further, that violation of this proposed statute would not prevent them from owning a firearm in the future. It is just a nominal civil monetary fine that to encourage responsible gun ownership and to report the theft when it happens or within 24 hours. And the way to think of this is not a way of re-victimizing a victim, but to put yourself in the shoes of our law enforcement. They make an arrest, they find a gun, and they have no idea where to start other than seeing if it's stolen, checking NCIC. And if it's not in there, they really don't know what to do. And if people aren't reporting them stolen, they have no way to find out where that trail started. What we know when our officers recover a firearm is that two things happened. One, a gun crime was committed, and two, the gun came from somewhere. If the gun was stolen, there was likely a string of crimes and crime victims, for that matter, between the time that it was stolen and when it was recovered. But we only know the gun was stolen if someone has reported it. And this bill would ensure that this reporting takes place. So I hope you all consider that. Thank you.
Thank you. You have a couple other folks behind you who'd like to speak up in support of the bill.
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. We support the bill. I just point out that the way the law stands at the moment, if someone is a habitual straw purchaser, the ability to get by every week or every month and buying these guns without having to report the fact that they no longer possess them, then allows them to get away with continuing to buy straw purchases. And if a policeman comes to their door and says, "We found this gun that you purchased," they only have to say, "Oh yes, I stole it. It was stolen from me." And this is something we have to get a hold of.
Thank you.
Good afternoon, Lori Haas with the Coalition to Stop Gun Violence. We know that gun violence disproportionately affects communities of color, and the flow of illegal guns into some of these communities needs to be addressed, and we need to find solutions for this problem. As a matter of fact, African Americans in Virginia are 8.2 times more likely to be murdered by a firearm than their white counterparts. And in 2017, nearly 40% of all illegal firearms traced and recovered in the Commonwealth of Virginia were recovered in Richmond and in the Hampton Roads region. We need to do something to help our law enforcement trace these firearms, solve these crimes, and stop the spigot of illegal firearms into our communities to reduce the gun violence that is disproportionately affecting far too many citizens in the Commonwealth of Virginia. We hope you'll support this bill. Thank you.
Yes, ma'am.
Good afternoon, Molly Voigt with Giffords, and we support the bill.
Thank you.
Mr. Chairman, Brian Moran, on behalf of the administration, we support the bill.
Thank you, Ms. Secretary.
Hello, Kelly Roscom on behalf of the Educational Fund to Stop Gun Violence. We support the bill.
Thank you. All right, we'd be happy to hear from those who wish to speak in opposition to the bill.
Philip Van Cleve, VCDL. we don't like the implication in here talking about criminal or civil liability. They keep trying to bring this in for something that's stolen from you. Also, how are the police going to be able to know to prosecute you that when you discovered the item was stolen? And indeed, the case where the police do show up and say, you know, this gun was used in a crime, it could have been stolen. You didn't know about it. It happens. So we oppose the bill. Thank you.
Thank you. Yes, sir.
Mr. Chairman, Chris Kopak again with the NRA. This bill would put arbitrary burdens on the victim of a crime and not the criminal. Again, firearm owners voluntarily and regularly report stolen firearms. Firearms owners who are potentially not aware of this requirement could then be put into jeopardy with possible charges and again fines as were mentioned. You know, if somebody was to come to my house and say, hey, look, we found this firearm, I'd probably say, uh-oh, maybe I need to hire an attorney, maybe I need to consult an attorney, instead of voluntarily and readily giving the police the information that they probably want to quickly continue the investigation. I think it could potentially hamper the police and the job that they're trying to do with this. So for those reasons, we oppose.
Thank you.
Mr. Chair?
Senator Peterson?
And I'm a little bit confused because I know it says civil penalty, but it's in 18.2. Would this be a Class 1 misdemeanor, or what are we talking about here?
This, it's supposed to be just a civil penalty. I'm not sure why
Charles?
Legislative Services put it in 18.2, but.
Let's ask counsel.
Mr. Chairman, it is a civil penalty. Although it is an 18.2, it's a civil penalty.
Okay, so if you're convicted of, I mean, is it a beyond a reasonable doubt standard? Do you have a right to a jury trial? Do you get a public defender? I mean, what are we talking about here?
You don't get a public defender.
Okay, but I mean, is it on your criminal record? I mean, it says civil penalty, but it's in 18.2.
Right. There is no criminal record. It's a civil fine. It's a civil fine. It's not a criminal fine. There's no jail time. There's no public defender. Yeah.
All right.
Let me ask a couple other questions. I mean, number one, you know, how do you know somebody's committed this offense?
Typically, the way this would work is if, you know, as you heard the representative from the police department say, sometimes they will show up to someone who has a gun that is registered to them that was used in a crime, and then that person says, oh, that gun was stolen 6 months ago. Well, that's in and of itself evidence that they did not report when it was stolen.
But you've got to get the admission from that person that, oh, yeah, it was stolen and it was a certain amount of time before. I mean, how do you establish, I mean, how long, I mean, what if somebody says, I had no idea it was stolen? I mean, how far back does this apply, and how do you establish when it occurred and, you know, when these cases are going to be time barred?
I think that the point in time when you, as far as you could go back, is when this law would take effect. So if we pass this and it takes effect July 1st, and on July 2nd, someone had a gun that was stolen, you know, June 30th, it wouldn't be covered. They wouldn't have had an obligation to report when it was stolen. It's only going forward. And I think anytime we pass something that would require a civil penalty if you don't comply with it, we hold hold people in the Commonwealth of Virginia to know that they're supposed to comply with that. So just as any other civil penalty we would pass, the public is expected to know, or...
So if 10 years from now, this passes, and 10 years from now, somebody is shot with a firearm and they come back to me and say, this was, you know, somehow traced to you, and I go, well, it's in my, you know, gun safe, and I go look in my gun safe and it's not there. I mean, how do I know when it disappeared, when it was stolen, when it was lost, and how far, I mean, if it was lost 10 years ago, am I going to still have civil liability for this civil penalty?
So it's within 24 hours of when you discovered the loss or theft?
Okay, so if I say, oh yeah, it was lost 10 years ago and I didn't report it, then I'd still, unlimited statute of limitations.
I think just as with any civil penalty for any violation of state law, there's going to have to be some proof that there was a violation. And so I don't, I think the same would apply here.
And I think that's one problem. Another issue that, and I don't know that you can address this, but another issue that I see with this is, as a primarily civil practitioner, I look at criminal statutes occasionally to see whether they've been violated, and somebody's been hurt as a consequence of a violation of a criminal statute. There's negligence per se and a civil cause of action. Doesn't this give civil liability for the criminal acts of a third party if I've failed to report that my gun was lost or stolen? I mean, I could be sued for that criminal act of the person because I was negligent per se in violating this statute. So, I mean, we identified that policy of the Commonwealth of Virginia earlier that we have long not held people civilly liable for criminal acts of third parties except in rare circumstances. I mean, it troubles me that would be, I'm just telling you, that's an issue that troubles me.
Mr. Chairman, you're right, but there's an easy solution for that. In subsection C, we would amend that to provide that no person who fails to report a lost or stolen firearm shall be held criminally or civilly liable for somebody else's criminal conduct. We would
You mean except for the civil penalty?
except for the civil penalty, that's right. The civil penalty would still be in place, but we would make it clear that we're not creating civil or criminal liability for the criminal act of somebody else.
Mr. Second.
All right, that amendment's been moved and seconded. Any discussion? Hearing none, all in favor of that amendment, signify by saying aye.
Aye.
All opposed? All right, that amendment's been made. The bill is before us.
Move report as amended.
All right, there's a motion, a report is amended.
Not the way they have it.
All right.
Ayes 6, noes 8.
Thank you.
Bill fails to report. Thank you very much. Senator Locke has a bill. Senator Lucas, you want to handle that? This is Senate Bill 1446.
That is correct, Mr. Chairman. Okay, Mr. Chairman, Senate Bill 1436 is purchase of handgun limitations on gun, better known as the one gun a month bill. Prohibits any person who is not a licensed firearm dealer from purchasing more than one handgun in a 30-day period and establishes such an offense as a Class 1 misdemeanor. The bill exempts from this provision, one little I, persons who have been issued a certificate by the Department of State Police under certain circumstances and with an enhanced background check. Two little I, law enforcement agencies and officers. Three little I, state and local correctional facilities. 5, licensed private security companies. 5, persons who hold a valid Virginia concealed handgun permit. 6, persons whose handgun has been stolen or irrevocably lost or who are tracking in a handgun. 7, purchases of handgun in a private sale. And 8, purchase of an antique firearm. You've heard this bill for years, dating back to 1992. So I think you're very familiar with it, Mr. Chairman. And
Indeed.
I know you're going to have a lot of testimony on it, so I think I'll start by calling up the secretary.
I hope maybe we don't have a lot of testimony, given the familiarity of the members of the committee on this, and I don't want to cut anybody off, but we'll give people an opportunity to be heard. Ms. Secretary, go ahead.
Mr. Chairman, members of the committee, Brian Moran, Secretary of Public Safety. The Senator has done a great job representing the bill. You are very familiar with it. We are in strong support of the legislation.
Thank you, Mr. Secretary. I think you have another person or two behind you.
Yes.
or three.
Good afternoon, Lori Haas with the Coalition to Stop Gun Violence. We strongly support the bill. We think that measures to reduce the flow of illegal guns onto our streets are warrant your attention and your support. Thank you.
Thank you.
Good afternoon, Kelly Roscom with the Educational Fund to Stop Gun Violence. Allowing for the limitless purchase of handguns facilitates gun trafficking, which I know you all are aware that Virginia is one of the top exporters of crime guns to other states. We strongly support this bill.
Thank you.
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. We support the bill in principle. However, we think it could be even better if you could strike VII, number 7, which is the private sales, because I think that's what spoils the entire thing, because it allows someone who's trafficking to go and purchase a box full of guns. Sorry, allows a person who's trafficking to go purchase a box full of guns from a private seller and then traffic them into another state.
Okay, thank you.
Good afternoon, Molly Voigt with Giffords, and we support the bill.
Thank you.
Thank you.
All right. Anybody wish to speak in opposition to the bill? Don't feel compelled.
Mr. Chairman, ladies and gentlemen, Robert Sadler, South Richmond. Before I got my concealed weapons permit, I was cheated out of a screaming deal on a beautiful wheel gun, and I desperately oppose this bill. Thank you.
Thank you.
Mr. Chairman, Chris Kopak again with the NRA, and as you're very familiar with it, and our stance is gun rationing doesn't work, and studies have proven that. We oppose the bill.
Okay. All right. All right. Council has pointed out to me that Senator Locke actually put in 2 identical bills, Senate Bill 1446 and 1034.
I think there's one bill that's been stricken. I thought I saw a bill that was stricken on your sheet.
Well, why don't we roll these together?
Okay, let's do that.
Or, I'm sorry, we can't do that. We'll do them in a block. How about that?
That's great.
Okay,
I'm sure she'd be pleased.
we'll see.
That is if you pass it.
Indeed.
And I so move.
All right, there's a motion to report this bill. Is there a second? Second. All right, there's a motion properly seconded to report the bill and send it to finance. Is that right, Senator Lucas?
That is correct, Mr. Chairman.
All right, vote is open.
Oh, Senator.
It's not letting me vote from
Give me
here.
1 second.
That's right, Senator Howell has it.
Come on. There you go.
There we go.
Okay, we got it. Well, she won't be pleased.
Ayes 5, noes 9.
You can present the other one if you want to.
You can do-
And do it again.
No, sir, thank you.
All right. Next, we've got, let's see. Hang on, we're going to do Senator Howell. We're going to do Senator Howell. I'm sorry, Senator Lucas, you have another firearms bill? 1454.
Mr. Chairman, I just love these bills.
Senate Bill 1454.
Yes, sir, Mr. Chairman, members of the committee, you've also heard this bill before. You heard it last year. I'm hoping for a better outcome this year. Currently, only sellers with a federal firearm license are required to obtain the results of a criminal background check prior to selling or transferring firearms. Private sellers are not required to perform criminal background checks. This bill is significant because the Virginia State Police reported a total of 3,457 denied firearm purchases in 2018 as a result of prohibited persons attempted to purchase firearms from federally licensed firearm dealers. This would prevent prohibited persons to obtaining firearms. It prohibits persons who are attempting to purchase from licensed dealers. It is very likely that even more prohibited persons are purchasing firearms legally from private sellers. Mr. Chairman, members of the committee, in case you're wondering if there's a fiscal impact, the governor's office has included $392,356 in the budget package for 7 positions to process additional background checks and an additional amount of $50,000 for the Woodruff Amendment.
Thank you, Senator Lucas. Anybody wish to speak in favor of this bill?
Yes, sir, I'm hoping.
Mr. Chairman, Brian Moran.
Mr.
Secretary of Public Safety, I'm just glad we're not keeping a batting average on this afternoon. That this actually is, if we are genuinely concerned about keeping the hands out of those who should not possess firearms. The mandatory background check is the legislation that Virginia needs to adopt. We're in strong support of the legislation.
Thank you.
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. You know exactly where I stand on this. We support the legislation.
Thank you.
Thank you.
Hello, Kelly Roscom with the Educational Fund to Stop Gun Violence. Background checks do not prohibit law-abiding citizens from purchasing firearms. It merely allows everyone to ensure that criminals do not obtain firearms. It makes very little sense to require federally licensed dealers to conduct such checks, but to allow criminals to purchase firearms illegally from third parties. Thank you.
Thank you.
Good afternoon, Molly Voigt with Giffords. For the reasons previously described, we support the bill.
Thank you.
Thank you.
Mr. Chairman, David Mitchell, General Counsel for Richmond Police Department, and RPD supports this bill.
Thank you.
Good afternoon, Lori House with the Coalition to Stop Gun Violence. For all the reasons stated previously, we support the bill.
Thank you. Anybody wish to speak in opposition to the bill?
Mr. Chairman, Chris Kopak, NRA, again, for the same reasons we stated previously about background checks, we oppose this bill.
Thank you for your brevity. All right. Okay, the bill is before us. There's a motion properly seconded to report the bill and send it to Finance.
Senator Howell, could you? Oh, I can do it from here. Okay.
All right.
Same result as last year.
Bill fails to report. Thank you very much, Senator Howell. Senate Bill 1096.
There are two. You want to do 1096 first?
1096, that's
Okay.
right.
1096
And this
is
is
a bill you
identical.
saw. No, it isn't. I have an amendment in the nature of a substitute.
All right. All right,
It
Senator
is
Howell
currently,
moves,
but it
Senator
won't be.
Saslaw seconds the adoption of the substitute. All in favor signify by saying aye. All opposed, substitutes before us.
This is a child access to firearms bill, and it does three things. First, it enhances the punishment for allowing access to a loaded, unsecured firearm by a child from a Class 3 misdemeanor to a Class 6 felony. It raises the age of the child from 14 to 18. And it modifies the standard of recklessly to negligently. And that's one of the major differences from what you'd seen prior.
So previously, it was illegal, or the way that it was, I gotcha. So you want to change the law to?
Change it from recklessly to negligently.
Oh, okay, elevate, make it easier to prove.
Yes. And change the age from 14 to 18 and make it a Class 6 felony. So it's got those three parts. And one of the reasons I feel this is so important is teenage suicide. Access to guns by teenagers is a major cause of suicide. We've had dozens of these tragedies in Virginia. And the hope is that by raising it to 18, we can prevent some of that.
So with a vehicular fatality, I mean, don't we have to prove recklessness in order for there to be, in order for it to be a felony, Steve? So
the problem,
what you're doing here is making simple negligence felonious behavior. Are you aware, and maybe counsel can answer this, is there anywhere else that you're aware that simple negligence in Virginia is criminalized? Is
No,
made felonious?
I just asked Charles. I'm not aware of any instance where simple negligence is elevated to a criminal offense.
All right.
But I would hope everyone would agree that leaving a loaded, unsecured firearm around a child is a pretty serious thing to do.
Negligently.
Chairman.
Negligent.
Senator Stewart.
Senator Howell, I'm curious, does any harm have to actually happen under this? Or is it just the act
I think it's
of
the act.
leaving? And so if I'll go, I'm a hunter. I don't shoot a lot of guns other than shotguns for hunting. But if I go out dove hunting or duck hunting or whatever, and I've got somebody who's 17 in the house, and I walk in, and they may have even been hunting with me, and I leave my shotgun, I always unload them before I bring them in the house, but if I failed to, and leave them in the corner of the house because I want to eat lunch or whatever, and the 17-year-old is in there with me, have I now committed a felonious act?
Yes, and you probably will have prevented, or you possibly will have prevented a teen suicide.
Well, no.
Senator Stewart.
Because we weren't going to shoot each other, we were going to dove hunt.
Yeah.
But I understand what you're trying to get to, but if I read this correctly, it is just the act of leaving it there. No harm, no damage has to come to anybody to be a felon.
Why don't we, Senator Howell, I'm happy to let you address further questions, or we can hear from witnesses who might want to address some of those issues if they're able.
Mr. Chairman, Brian Moran, Secretary of Public Safety. This did come before the committee last year, and some of the astute members recognized that this actually, without reckless, we eliminated reckless, and it was a kind of a strict liability standard, and so negligent has been included. So that's one change in the bill to try to recognize some of the concerns of the committee. With respect to what the senators asked, whether you're hunting with your 17-year-old, you'd have to show that was a negligent act, and so the senator well knows those cases can be litigated, but whether or not that would have been negligence, I don't.
Do I have to show it?
Well,
it's fact.
Mr. Chairman?
I guess, we've spent a little time in other contexts talking about hypervigilant, maybe the hypervigilant law enforcement officer. The hypervigilant law enforcement officer who may be hunting with Senator Stewart could charge him with a felony.
I'll say 28 states do have cap laws, and 15 of them have a negligent standard. So this isn't, it's not.
Mr. Chair?
Okay, Senator
Unheard
Peterson.
of. 15 states do have a negligent
I'm
standard.
going to sort of reach backwards, but we allow you can take your child hunting with you. In fact, we have licenses there. I think there's a license exemption. And so you could take your child with you. You could be sitting in a blind. You could have a loaded shotgun. You could hand it to your son or daughter. And what if they then misused it? Would it be negligent? I mean, I think we have to have some specific carve out for hunting, because otherwise, but the weapon by definition has to be loaded, or else you're not hunting. You don't hunt with an unloaded weapon.
Not successfully.
It's a waste of time. I've tried it. So I guess my question, I think we'd need to carve out going hunting, because that's not the same as leaving it on your kitchen table.
I think that's maybe one issue. I think that
there are several sections of the bill. There's the age change, the penalty stage, and then the legal standards. So there are three components of the bill, obviously subject to the will of the committee.
Yeah. All right. Mr. Secretary, anything further?
Just the age.
You okay?
Mr. Well, I was hopeful that we could amend it so just the age part would remain, raising it from 14 to 18, not change the negligent, reckless, and not increase the penalty. Because my goal is to really help avoid the teen suicides.
I think that makes sense, because that's the law in the books right now.
No.
Mr. Chair, then you're striking all the new.
Senator Deeds.
Striking all the new language and changing the age.
Just changing the age from 14 to 18.
I'll make that motion.
So the only change to this statute would be the change on line 12, changing 14 to 18. Is that right?
Yes,
It remains reckless, right?
it remains reckless.
That's correct. Okay.
And a misdemeanor.
So, all right. So Senator Deeds makes that motion to amend. Senator Peterson seconds it. All in favor of that amendment signify by saying aye.
Aye.
All opposed? All right, that amendment is made. Anybody else wish to speak to the bill?
Could you report that amendment, because I was talking.
Good afternoon, Mr. Chairman.
That's the only change.
Ari Davis with the Educational Fund to Stop Gun Violence.
Yeah.
And I want to speak specifically to the age component and talk a little bit more about the data around teenage suicide. So in 2017, 45 teens and children died by firearms in Virginia. This was the highest in 35 years in the state. Teen firearm suicide makes up the majority of those 45 deaths, and 4 out of 5 teens that died by firearm suicide were not covered in the current law because they were under 14. So I looked a lot into the evidence around this, and there's like robust evidence that shows that increasing the age to 18 reduces suicide. There's actually one study by Rand that kind of looked at all the evidence, and they cited an 8% reduction in overall teen suicides. So I strongly urge you to support at least that component of the bill because it really will have a strong effect at reducing teen suicide in Virginia.
Thank you. All right, next.
Hi, good evening. My name is Gina Reeder. I'm a Chesterfield County public school parent, a resident of District 10. I'll keep it short because we've already missed our workout on Wednesday night, Senator Sturtevant. I also had the privilege of serving on the Chesterfield County Safety Task Force Working Group 3 under the leadership of Secretary Moran. I've spent the past 6 months in this group discussing the broader issue of school violence and mental illness, and I will tell you there was broad consensus among the bipartisan constituents that were invited to be part of this group to talk about child access as part of the larger problem of school violence. Unfortunately, Speaker Cox's committee chose not to address this as a component of the larger issue, and we feel that that was very short-sighted. The current statutes that are in place are not working. We still have an alarming statistic of children that commit suicide and bring a firearm to school to commit acts of violence. We know that safe storage laws would do much to save lives and to deter. The current statutes do not have any mechanism for us to hold parents accountable when they are negligent. I'm saying to you that since there is constituents support and since there is an elevated conversation about this at the county level in the districts that you serve, it only makes sense to also have this issue be considered and taken seriously by this committee and at the state level. And I think to not do so would be noticeable. Thank you.
Thank you.
Molly Voigt with Giffords, and we support the bill. Thank you.
Good afternoon, Lori House with Coalition to Stop Gun Violence. I support the bill for the many statements and comments that have been offered, and would just like to suggest that this committee addressing this situation and the teen suicide and the child firearms death that are increasing in the Commonwealth of Virginia will have the added effect of making parents and gun owners stop and think, where's my firearm, where is it stored, how is it stored, is it accessible? Access is one of the leading reasons that we see these firearms deaths among teens and suicides. A full 82% of adolescent firearm suicides involve a gun belonging to a family member. So we would encourage the committee to consider this bill. Thank you.
All right, step right up.
Philip Van Cleve, VCDL. We oppose the bill. There are many cases, and it happens every year, where somebody 14 to 17 ends up saving their life at home because they had access to a firearm, home invasions and stuff. And there have been the opposite, like in California, there was a horrible murder of 3 children, and the older child could do nothing to stop it because the guns were locked up. She knew how to use those guns. She hunted with them and everything else. She couldn't get to them. So everything kind of has this balance. So, and also suicides, guns are not the only way to commit suicide. In fact, a lot of things are very, very popular. And if somehow you were magically able to get rid of guns, unfortunately, you're going to have to look at suicide from a different angle. It's not the tool that's used, it's trying to stop the person from wanting to kill themselves that's the key. Thank you.
Thank you.
Mr. Chairman, Chris Kopacki, representing the National Rifle Association. We oppose this legislation as we do think it would restrict the ability of young people to use firearms for lawful purposes. In addition, we think Virginia laws on child abuse and neglect already cover these situations. 18.2-371.1, abuse and neglect of children, where any parent, guardian, or person responsible for the care of the child under the age of 18 who is willfully act or willfully omission causes or permits the serious injury of life, health of that child is guilty of a felony. So we think that's covered. Plus, this brings to mind a recent incident that occurred in Goochland County not too long ago. If you can remember the news reports, where a deranged individual flew halfway around the world from New Zealand, I believe, to Goochland, and was breaking into a family's home, and the mom yelled to the daughter to go upstairs and get the gun. Daughter brought the gun down. Mom used that to defend and save their lives. For those reasons, we oppose.
Thank you. All right, the bill is before the committee. Senator Stewart.
Mr. Chairman, although I almost always vote for every one of Senator Howe's bills, this one concerns me. And there are already at least several statutes, I think, that would address this. Reckless endangerment, child endangerment. There's some others as well. Maybe I'm wrong. Mr. Benjamin's looking at me, but if I was a prosecutor, I could find something, because I used to. At any rate, I gently suggest we PBI this bill.
All right, there's a motion. Is there a second? It's been moved and seconded to pass the bill by indefinitely. Substitute motion is to report the bill
As amended.
and it does not need to go to finance as amended, correct? Yeah. All right, the motion, substitute motion is to report the bill. Roll is open. Report the bill.
Ayes 6, noes 8.
All right, the bill fails to report. Do you have another one, Senator Howe?
I do, 1078.
1078.
And this is a bill that last year passed out of this committee 12-3, and then sort of hit the shoals of finance and didn't make it out. As you remember, 2 or 3 years ago, we had sort of a package of gun bills, and Senator Reeves and I were chief patrons of 2 of the 3 bills. The one I did at that point was protective orders in family abuse cases. If someone had a protective order, a permanent protective order against them in a family abuse situation, they were not permitted to possess guns. What we did with that was actually put us at some odds with federal law. Federal law applies to all protective orders, not just domestic abuse protective orders. So what this bill is doing is saying that for any final permanent protective order, it would be covered. And the part that is sort of most important to me is the stalking. It would cover for stalking, but it would also cover for other situations that were not involved with family abuse.
All right, anybody have any questions of the patron? Anybody wish to speak in favor of the bill?
Mr. Chairman, Brian Moran, Secretary of Public Safety. Appreciate Senator pursuing this again. This is a system that already exists, and so she's merely adding another crime to the protective order, the potential issuance of the protective order. So I think the process issues and due process, so forth, have been already met. And actually, the implementation of this law since 2006 has indeed resulted in numerous felony prosecutions. It's actually being very successful with respect to domestic violence. That was limited to family, a household member, if the committee would remember. This expands it, so we're very much, again, in support of the legislation.
All right, thank you.
Josh Horowitz, Educational Fund to Stop Gun Violence. Thank you for this opportunity to testify. There's a lot of research, good research out there that shows that the states that have adopted protective orders, gun prohibitions on protective orders save lives. We strongly recommend and ask that you support this bill to make sure that people who are abusers don't have access to firearms and all the different protective orders.
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. We support the bill. The best predictor of future violence is past violence, so we think these people should be disarmed.
Lori Haas with the Coalition to Stop Gun Violence, and we support the bill.
Thank you.
Molly Voigt with Giffords, and we support the bill.
Thank you.
Mr. Chairman. Mr. Chairman. Mr. Chairman.
I'm sorry, who, Senator Reeves?
Question for Secretary Moran. Mr. Secretary, based on the provisions of the deal that we all worked through, we had inadvertently left this section out, and this is the section that would make it identical to the federal statute. Is that the case? We just missed it?
Mr. Chairman, members of the committee, that would depend on your definition of inadvertent. We did attempt to expand to additional, but our focus was on the family and domestic violence cases. Senator Howell at the time was adamant to expand, and it just didn't get into our agreement, and she committed to continue to try to expand it, and so we're back very much supporting the expansion. And
writing.
So that is kind of the description of the discussions we have. So,
Mr. Chairman, follow-up question.
Senator Reeves.
Mr. Secretary, so I'm not an attorney and you are, and you're a good one. What else, as far as this expansion goes, in the pursuant to Code 16-1-279.1, or I know what the 19.2 code section is. I don't understand what a tribunal of another state and some of these other things are. So if you can clarify some of that legalese for me, I have no idea what that means.
I think that's just the language borrowed from the other code sections. That's throughout the code, and I'm sure Legislative Services just lifted the language from the other code sections and placed it in here when we include 19.2, 152.10. Is that correct, Charles?
Counsel. Charles.
Mr. Chairman, that's correct. Basically, it's just saying that if there is a protective order issued by another state, the tribunal being, because it may not be a court order, it may be a magistrate order or the equivalent of a magistrate in a different state. That's why I'm saying it's tribunal, capturing all other protective orders from other jurisdictions.
All right, Senator Stewart.
Thank you, Mr. Chairman. I don't know who to direct this question to, Senator Howe, but and maybe it's staff or Mr. Benjamin. Is this just dealing with domestic abuse cases, family domestic cases?
No. We've already covered family and domestic violence cases. This is for the other cases for which there's a permanent protective order issued.
Like, can I have an example?
So, for example, like stalking is the one I was using.
And Mr. Chairman, could I just ask, maybe give me a few more ideas of the cases we're talking about under this? Because I don't know the sections.
Charles.
Mr. Chairman, the section 19.2, 152.10 is the permanent protective order. Those are the protective orders that are good for 2 years. It's not a preliminary one or a temporary one. These are the 2-year protective orders. And this section basically, when it's issued, is for basically criminal offenses that result from the commission of an act of violence, force, or threat. And that's why it's these situations where there is not a family abuse issue, but a issue where a protective order would be appropriate, and it's not between family members or in the family abuse context.
Okay.
Smith, I mean, the legislature has deemed those cases sufficiently dangerous in nature that you have created a permanent protective order to protect that class of people. And all we're doing is, all the senator's bill does is expand those into our protective order legislation that we were able to get done a couple of years ago.
Senator McDougal.
Mr. Chairman, I don't know that this was on the original docket agenda.
It was not.
On here, and I think that this bill does two separate things, and candidly, I'd like to look at with the subsection for the beginning part of the bill, but then at the end of the day, we're also going to have to talk about this puts in a new certification process in writing, and I'd like to do a little research of whether we've required anybody to affirmatively certify something in writing and what we would do about disabilities and people that were, did not have the ability to write. I mean, that's certainly something we would want to talk about. But, Mr. Chairman, to make sure we don't screw this one up, I'd just as soon go by till Monday for us to have a conversation.
Without objection, this will go by for the day. All right. Senator Chase, and we're going to have to roll through a couple of these bills. I know we have two more bills of Senator Deeds after this that I'd like to take, and we have, I believe, one mechanics lien case that I know we have witnesses here for, have been extremely patient. So, and everybody here has been patient, but let's go to Senate Bill 1012. Senator Chase.
Thank you, Mr. Chairman and members of the committee. This bill actually passed out of this committee and out on the floor of the Senate, actually made it over to the House. I'm actually asking that we put the bill in a different format here. There's an amendment which I would like to offer up.
All right. Let me ask you before we adopt this amendment. So this last year, what we did was we actually passed an amended version of this out of here on a 12-3 vote. It met a good fate. You want to do something different than was successful last year? Or
I would like to do exactly, and this is different than what probably the amendment that is going out right now.
So you would like to conform your bill to
the
last
same
year?
bills, yes.
All right. So
Thank
we
you.
won't act on the substitute that's being passed
Correct.
out.
Last minute adjustment.
We have Senator Stanley moves and Senator Reeves seconds that we conform this bill to the substitute version that passed out of the Senate, out of this committee on a 12-3 vote last year. All right, that's been moved and seconded. All in favor of that amendment signify by saying aye. Aye. All opposed? Passes 1-0. All right, Senator Chase.
Okay, very briefly, Mr. Chairman, you all saw this bill last year. Under the current law, any current member who is a firefighter, EMS, they can already conceal carry. It's the law. And typically why most do not carry is because they have a policy in place by their local government which restricts them and keeps them from carrying, but that is not the law. They can currently carry in the state of Virginia. But the challenge is because of the, I think it was a law and executive order, they can no longer carry in state buildings and where it's currently restricted, as in our schools. So if I'm a firefighter or if I'm an EMT and I go into a situation, an emergency situation, then I have to immediately do something with my weapon or I'm in violation of this law. All this does is it allows the firefighter or the EMT to conceal carry, not open carry, conceal carry their weapon in whatever situation it is. And if you think about school shooting situations, that type of thing, they're not going in there to be police officers. They are simply, this is self-defense. And in some of our areas in rural Virginia, like in Amelia and Colonial Heights, My Colonial Heights Chief of Fire and EMS, A.G. Moore, supports this measure, as did Amelia County Volunteer Fire Department, Justin Warvack, also supported this. The only firefighters in my district who didn't support it were Chesterfield.
Well, Senator Chase, every year is a different year, but last year only Senators Saslaw, Howell, and Lucas voted against this bill. So unless a lot's changed, I suspect you're not in bad shape. Anybody wish to speak in favor of this bill or signal their support for this bill?
Let me just ask a question. What was the outcome of this bill?
So the outcome of the bill is it passed the Senate, the full Senate, went over to the House subcommittee, passed out of the subcommittee, and died on the floor. There was some misinformation. This year, Delegate Nick Freitas is also carrying a similar bill on the House so that he can more clearly explain.
Senator Saslaw.
You know, the people that run the police department in Fairfax County and the fire department are not bashful people, but they've never told me we need to have this bill. Why is that?
Mr. Chairman, Senator Saslaw, I would tell you, Fairfax City is a whole different environment than Amelia County, which is in my district, which is more rural. We do not have the same resources that your city provides, and many times our firefighters and our EMTs are volunteers who are having to perform multiple functions. It's more of the suburban areas typically don't have as much of a need as more of my rural areas like Amelia and Colonial Heights have desired this. It's just a different environment.
All right. Any other questions? All right. Anybody wish to speak in favor of the bill briefly or signal your support for it?
Philip Van Cleve, yeah, we support this. And there have been cases where firemen have been intentionally called or EMS to a location and ambushed. And they have a right to defend themselves. They'd be carrying concealed. Nobody would even know unless their life was in danger.
Thank you. Anybody wish to speak or signal their opposition to the bill? Okay. Thank you. Yes, ma'am.
Good evening, Mr. Chairman and members of the committee. My name's Ariel Matsangos. I am a public health fellow with the Educational Fund to Stop Gun Violence, where I do translational evidence-based research. I received my master's degree from the Johns Hopkins University, and I'm here to urge you to vote against Senate Bill 1012. So before I started my career in gun violence prevention, I worked for over 6 years as an advanced EMT and crew chief, both nationally and Vermont state certified, including rural areas of Vermont. And as a crew chief, I often had the authority to act as scene command for many mass casualty incidences, some of which included firearm violence. And I worked hand in hand with firefighters and law enforcement. So my job and our mission was to mitigate and stabilize matters of disaster and crisis, save lives, and try to make sure everybody gets to go home. Never was I trained, and never did I entertain the idea of using deadly force to ensure my own or my crew's safety. This was exactly why we had law enforcement and why we worked so closely with law enforcement to establish their safety, our safety, and the safety of the scene. And I'd like you to know that when I was immersed in patient care, I was completely immersed in patient care. I was completely immersed in patient care when I was beginning to initiate 20 minutes of CPR on an 8-week-old dead, cold baby with their parents in hysteria behind me. I was completely immersed in patient care when I was treating a 8-month term pregnant lady after she was violently attacked and shoved down a flight of stairs, who is now bleeding from her vagina in a case of domestic violence. And the assailant could not be found, but guess who I could find? Law enforcement with their firearms, establishing scene safety, our safety, and their safety. So I just want to highlight that I was completely immersed in patient care, not firearm retention. Fittingly, I'm opposed to this bill. So thank you for your time.
Thank you for being here. Appreciate it.
Mr. Chairman, members of the committee, Brian Moran, on behalf of the administration, appreciate the patron substitute, but having read it, I don't think it addresses our objections, and one of which is certainly training for the EMS, and two, just introducing a firearm into these very difficult medical services. We've seen on numerous occasions where that you don't want a firearm being introduced into a situation that the previous speaker so eloquently described. So we would continue to oppose this legislation as written.
Thank you, Mr. Secretary.
Good evening. I'm Dr. Rochelle Brackney. I'm the Chief of Police for Charlottesville. I would adamantly oppose this as a 35-year law enforcement professional. One of the things you want to consider is when you're in the middle of an emergency situation is what does your training provide for you to do? And as a firefighter and their emergency personnel, their primary training is around fires and emergency procedures. They don't train on weapon retention. They do not train on or have any standards as to the type of holsters they will put in. Are they a level 3 holster in which it would take a lot of different ways in which that weapon would be taken from that person? I would also then additionally say is once that weapon has been introduced, we have law enforcement professionals who have been killed with their own weapons and they're trained to retain them. Imagine what your EMS personnel or your firefighters would experience if someone then took that weapon off of them. So thank you, and I would consider that you do not pass this bill.
Can you hold on one second? Senator
Yeah,
Sasslaw.
I have just one question to ask you. You heard what Mr. Van Cleve says, that there's cases where EMT people have been called and they get ambushed. Do you know of a single incident where that's ever happened in your career?
Not that I know of, and I was a commander in the city of Pittsburgh for 31 years, the chief of police of George Washington University in Foggy Bottom, very urban area in D.C., and then now as the chief of police in Charlottesville. So no, not that I can recall.
Thank you.
Thank you. All right, yes, sir.
Thank you, Mr. Chairman. I'm Ed Rhodes. I'm speaking on behalf of the Virginia Association of Rescue Squads, the Emergency Medical Services Association, Regional EMS Councils, and the Virginia Professional Firefighters Association. Mr. Chairman, this particular bill, I haven't found anywhere in it where it says firefighters. It's only relating to EMS personnel. They don't need the training. They have the respect of the community when they go on calls. I spent 30 years in the Henrico Fire Department, and I spent 40 years in a volunteer rescue squad. The question is this bill really needed, since the agency head can authorize them to carry if they wish?
So you all oppose this?
Yes, sir.
I'm sorry, but the time's up.
Okay.
Thank you, Ed.
Mm-hmm.
Yes,
Hello,
sir.
everyone. I'm Joey King. I'm the Vice President of Life Care Medical Transport Service. And my comments are from representation of the Virginia Ambulance Association. And clearly, without standing on my head and spinning around, we're opposed to this.
Thank you.
We need EMS people doing EMS skills and care of the patient. We're not trained.
I'm afraid the time
handle-
is up. I just
It
need
is?
you to identify yourself and whether you support it.
So you got my point?
I got it.
All right, thank you.
I'm sorry.
Thanks.
All right. All right. Bill is before us.
Mr.
Senator Sasslaw.
Yep, you just heard from the people, and you heard from the lady over there who's head of Charlottesville Police. She's never heard of a single incident. That's number one. And number two, the EMT people, representatives here, they don't want the bill.
Mr. Chairman?
So hang on. We're not going to, this late hour, we're not going to argue. You
No, I
want to make a
understand.
motion?
I'll make a motion that it be passed by indefinitely.
All right, it's been moved and seconded that the bill be passed by indefinitely. All right,
Mr. Chairman?
we'll open the vote.
Aye, 7, no 7.
All right, is there another motion? It fails. The motion to pass by indefinitely failed. All right, it's been moved to report. Is there a second? It's been moved and seconded to report the bill.
Ayes 8, no 6.
All right, the bill reports. Thank you. All right, Senator Deeds, 1473.
This bill, they passed that last year.
I've got two bills, Mr. Chair. They both are in response to the events occurred in Charlottesville last summer, summer 2017. 1473 would authorize any locality to adopt an ordinance to prohibit the possession of firearms, ammunition, components of firearms, or any combination in a public space during a permitted event. Now, and using Richmond as an example, if there's some kind of a permitted event around the Robert E. Lee statue on Monument Avenue, the Commonwealth of Virginia owns that and can already prohibit a firearm, from being held there, being used there, being possessed there. But across the street in the city of Richmond, the city can't. It just makes sense. It's logical that locality should have this authority. Mr. Chair, as you know, I grew up way out in the country. I grew up hunting. I grew up with firearms in my house. I have firearms in my house today. I was in Charlottesville last August 12th, 2017, and there were lots of police officers there, but there was lots of confusion. And there were lots of introducing firearms in that situation just created a dangerous environment. This is a public safety issue, and I hope you'll give it your consideration.
All right, Senator Deeds, thank you very much. Anybody wish to speak in favor of this bill? If you do, please step up.
Good evening again. I'm Dr. Rochelle Brackney and the Chief of Police of Charlottesville. I would also bring to your attention that I'm also a native of the city of Pittsburgh, where they had a mass shooting that occurred at the Tree of Life Synagogue. And you often hear the response that the only person that can stop a bad guy with a gun is a good guy with a gun. Well, let me tell you, we had 4 officers who went into the Tree of Life, SWAT trained, and they didn't stop the bad guy with the gun. The key is to be able to regulate and disrupt those type of persons and patterns when you do introduce gun violence into a situation. For the city of Charlottesville, what we are asking is the ability to look at something more closely, to scrutinize it, to say the possibility of a weapon being introduced into a festival or at a tot lot or where there's a spray park that someone could be sprayed with weapons and bullets. So we are adamantly against this type of, for this type of legislation. It is getting late, where we have the ability to stop those individuals who would come into the areas and cause harm when you might want to have the opportunities to celebrate the communities instead. Thank you.
Thank you. Yes, sir.
Thank you, Mr. Chairman. My name is John Blair. I'm the city attorney for Charlottesville. I'd just like to make 2 quick points. The first is in Virginia Code 15.2-1714, when there are emergency situations, the chief of police is authorized to create clear zones and simply keep citizens out of those zones during the emergency. Obviously, I think everybody on the panel is aware of what happened in our city in August of 2017. It is hard to not argue that that was an emergency situation and that beforehand, the permitting process should have been afforded the city to prohibit firearms when the city had more than adequate reason to believe that there were going to be a number of firearms and violence that was about to occur. The second point I would just like to address to the committee is I spoke to our Director of Finance before we came down today. This past year, the city spent $1 million in preparation for August 12th of 2018 and during August 12th of 2018. Obviously, if we had had this authority, I think those costs would be less, as the law enforcement presence would have had more opportunity to have a more concerted effort rather than the expansive and expensive effort that you saw. It's Virginia Code Section 15.2-1714, and it's for emergency situations.
Thank you.
Good evening, Mr. Chairman. Mark Birnbaum, Office of the Attorney General. The Attorney General supports this bill.
Thank you.
Thank you.
Molly Voigt with Giffords, and we support the bill.
Thank you.
Thank you.
Mr. Chairman, members of the committee, Nikki Zamosny, I'm the Assistant Secretary of Public Safety and Homeland Security, and I was also the Director of the Governor's Task Force following the 2017 events in Charlottesville, and I was in Charlottesville this year during the events, and we believe that this would strongly enhance public safety, so we support the bill. Thank you.
Mr. Chairman, David Mitchell, General Counsel for the Richmond Police Department. One thing I would like to point out that hasn't already been mentioned is that citizens have expressed a deep fear of expressing their opinion and their ideas when facing people that have opposing views that are holding assault rifles, shotguns, handguns, body armor, and all of these things. And certainly it's not unreasonable for them to feel this way. I think we are sacrificing everybody's First Amendment rights in order for some to take a very expansive view of the Second Amendment. And not only that, Richmond spent over $500,000 in preparation for the protest shortly after Charlottesville, and I don't think that would have been necessary if firearms could have been prohibited. Thank you.
Thank you.
Educational Fund to Stop Gun Violence supports this bill. Thank you.
Thank you. All right, those who wish to register their opposition.
Philip Van Cleve, VCDL. Yeah, we oppose this bill. When you're in an event like this, especially what happened in Charlottesville, where they let two groups that they knew didn't like each other merge. They basically allowed them to merge together. And then, geez, they were surprised when something bad happened. If I'm stuck in a situation like that, I want to be able to protect myself. Our right to self-defense is particularly important when the police aren't there to control these crowds. I mean, you're in a situation, something goes wrong. Again, I think our preemption laws are wonderful. They make life simple for gun owners. You learn the state law and you're good no matter where you go. We really don't want to go back to the bad old days where you needed a map to figure out where you could do this and where you couldn't do that.
Thank
So
you.
we oppose the bill.
Thank you. Yes, sir.
Mr. Chairman, Chris Kopacki, NRA. This bill goes against the standing preemption statute in Virginia, which does protect those law-abiding people from accidentally becoming criminals due to a patchwork of laws that are consistent around the Commonwealth. Therefore, we oppose it. Thank you.
Thank you.
Mr. Chairman, ladies and gentlemen, Bob Sadler, South Richmond. With every possible respect, using Charlottesville is a false argument. I was actually quite proud of the way gun owners handled themselves. Every gun owner in the city kept their cool, despite the incredibly intense confrontations. They kept their cool. Even when a tourist from Maryland fired a warning shot, it did not turn into a shooting gallery. This argument just doesn't hold water. Thank you.
All right. Thank you very much. All right, Sir and Deeds.
I move the bill be reported.
You know, what I wanted to point out, and same concern that I think was articulated last year with respect to this bill, and I kind of wish that taking another, well, I don't know whether taking another look at it or not, but I mean, this is, it's broad and vague. It deals not just with participants in an event, but passers-by, people in the area. It involves people who are just happen to be in a public space, not those who were there, you know, participating in the event. May be people who live there, residents, may not even know about the occurrence of the event. So those are a few of the concerns that I expressed in the past, and
Well, I understand.
I still have those concerns.
It's still a permitted event. The public's gonna have notice that the event is occurring, and as you and I both know, ignorance of the law is no excuse. There are people that stumble into the violations of the law every single day. For example, when you go from state to state, you go from a 70-mile-per-hour speed limit to a 65.
But this isn't ignorance of the law. This is a moving zone of public events that may be declared to be areas that are going to be impacted by this. I mean, you don't know about the existence of a permitted event, and there will be under this different laws in different jurisdictions. So I don't mean to argue with you. I'm just trying to express my concerns.
I appreciate that. I appreciate that, yes.
The bill is before us.
I move
Senator
report.
Deeds moves to report. Is there a second? Second. All right, it's been moved and seconded that the bill be reported. Roll is open.
Ayes 6, noes 8.
All right, the bill fails to report.
Mr. Chair, the other bill I have is 1482, and it's slightly more narrow. It's significantly narrower. It simply adds Albemarle and Charlottesville to a list that already exists in 18.2-287.4 that allows them to join several other large, densely populated cities and counties, and that happens to be Alexandria, Chesapeake, Fairfax Falls Church, Newport News, Norfolk, Richmond, Virginia Beach, the counties of Arlington, Fairfax, Henrico, Loudoun, Prince William, and where they can, it's unlawful to carry a loaded rifle or pistol that can hold more than 20 rounds or designed by the manufacturer to accommodate a silencer or equipped with a folding stock, or to carry a loaded shotgun with a magazine that can hold more than 7 rounds. It doesn't apply to law enforcement, security guards, military personnel, those engaged in lawful hunting or recreational shooting. This is a bill that was introduced last year, and it's just another way to solve the problem, a little more narrow.
All right, and I believe that it failed on a 7-8 vote last year in committee, and I will gladly hear anybody who wishes to step up and register their support.
Okay.
Mr. Chairman, Andrew Goddard, Virginia Center for Public Safety. We support the bill. Since it's already an option available to a large number of cities, we think that any other city should be allowed to join in.
Thank you, Mr. Goddard.
Thank you, Mr. Chairman, members of the committee. John Blair, City Attorney of Charlottesville. Our city does support this bill. Would like to point out, I actually grew up in Senator Stanley's district in Pittsylvania County, and I can understand certainly the polarity that attaches to firearm issues, but this particular bill is about the city of Charlottesville. And I just point out a couple of points that there are 8 cities listed in here. If you go by individuals per square mile, Charlottesville actually has a denser population than 6 of the 8 cities, including Richmond and Norfolk, and those cities have been provided this authority, so we'd like you to consider that fact. And I'd also point out that the legislature does obviously look at density when we're talking about firearms. If you take a look at 15.2-1209, counties can prohibit shooting of firearms in what are considered heavily populated areas, so long as they have an exception for deer hunting. Again, density does seem to, the legislature acknowledges it is a factor in firearms legislation. So we would ask that you support this bill. Thank you for your consideration.
Thank you.
Once again, Chief Brackney, Charlottesville. I would actually support this bill as well. When we think about density, we often just think about population and those persons that we capture within the city. We don't think about those persons who are actually visitors or those individuals, like the University of Pittsburgh has another 26,000 students that are in that area. We don't talk about the number of individuals who come to work in that community. So although it may start out looking like 47,000 in your population, on a daily basis, we are looking anywhere between 125, 200,000 people who come into the Charlottesville area in order to work, play, worship, attend educational opportunities, or even just as now a destination location, which we would really need your support in order to make sure that we have a safer city. Thank you, I appreciate it.
Thank you.
Mr. Chairman, David Blunt here on behalf of Albemarle County, with its geographically surrounding Charlottesville, also made the request to be added to this bill by Senator Deeds and is in support today.
Thank you. Anybody wish to register their opposition to the bill?
Philip Van Cleve, VCDL. We oppose.
Thank you. Yes, sir.
Chris Kopacki, NRA, for the same reasons last year and previously mentioned about the preemption statute. We oppose.
All right, thank you. All right, the bill is before us.
Mr. Chair, I think last year Senator Stewart pointed out this was much narrower than the last bill that I had.
That's a very subtle.
And it also, it simply puts
Voted for your bill last year?
You voted for this bill last year.
Hey, you're reminding me that I voted for
I am
your
reminding you, yes.
Out of order.
It simply adds Charlottesville and Albemarle to a list of localities that are similarly situated, and it's a very simple matter.
Is that your motion to report?
That's my motion to report, yes.
It's been moved and seconded that the bill be reported.
Did you vote me? Hold on. Wait a second.
I'm going to close the roll.
I think you gave your proxy. Aye, 7, no 7.
All right. The bill fails to report on the narrowest of margins. And I'm sorry, I think I lied. There are 2 more bills we're going to take up. Senator Edwards does have one that 1303 we're going to take, and then Senator Peterson's bill, and that's going to be it. 1303, Senator Edwards.
Mr. Chairman, members of the committee, Senate Bill 1303 is requested by the city of Roanoke. Incidents have occurred in the paper, and as people are well aware of, in Roanoke City, where a couple of years ago, I believe it was, a gentleman sat on the front row of a city council meeting. There were children there. He pulled out his gun and put it on his lap and say, "Look what I can do," in effect. And it caused some consternation with a lot of people, including some members of city council that felt uncomfortable, especially with children there. And another incident happened recently where a guy got up in front of the city council members, a disgruntled employee who said some very unkind things, threatening city council members. He didn't have a gun, but he was threatening them with what could happen if they, didn't listen to what he had to say, and he had to be escorted out of the room. Of course, he did not have a gun, fortunately. But they're very concerned about people showing up at city council chambers threatening with guns or just threatening people. And so the bill is very narrowly drafted. What it would mean is any locality by ordinance, it'd have to pass an ordinance that could prohibit firearms at a regular or special meeting that is notified, that the public's well aware of, provided that the notice of such prohibition of having guns in the chambers is publicly posted, and the meeting room of the city council's regular or special meeting is owned or operated by the locality. In other words, at the time of the meetings only, not keeping them out of the building, except when there's a special meeting or a regular meeting of city council and there's a posted notice, you cannot have guns there. So nobody's being kept caught by surprise.
Senator Edwards, this is the same bill that you introduced last year?
I did.
All right.
And I have Rob Catrins here representing the city of Roanoke.
Wonderful.
Probably like to say something. I expect he will be in favor of it.
All right.
Mr. Chairman, members of the committee, this is the second year that the city of Roanoke has had this bill on their legislative agenda. They feel very strongly that they would like to have the authority to prohibit firearms from being in council chambers while council is in session in their regular council chambers, not if they're off-site. We'd appreciate your support for the bill. Thank you very much.
Anybody else wish to register support for the bill? You can do it by raising your hands or coming up. Those in support? Thank you. Anybody in opposition? All right. All right, Senator Edwards, I take it you move.
Move to report.
I'll second it.
It's been moved and seconded that the bill be reported. All right, the
6 noes 8.
bill fails to report. Senator Peterson, and then if we can give Senator Reeves grace and stick around for his bill after Senator Peterson's. We have a witness who's been very patient in waiting to testify on Senator Reeves' bill. Senator Peterson.
Thank you, Mr. Chairman, members of the committee. This bill has nothing to do with guns. Yeah, I know. It actually has to do with...
Eminent domain.
Actually has to do with general contractors, subcontractors, and right of offset. It's an amendment to section 43-13, and just a little bit by way of background, a couple years ago I brought a bill on lien waivers, which was supported by the subcontractors. We passed that into law. It's been a great addition to our law. And this year, the Subcontractors Association of Washington came back, and basically, the issue is what's called the right of offset, and it deals with the following situation. If you're a subcontractor working on a large project and the general is paid money, let's say $1 million from which you're going to be paid for the work that you've done on the project, they are legally required to pay down to you what you're owed, or else they can be held liable under 43-13. The issue arises, however, when they take money that they're owed and they use it to offset against other debts. In other words, if they owe money to somebody else or they're in a dispute with somebody else, and they offset that money such that you are not paid for your work on the project. And I can give some specific examples on this, and I had a long narrative, but I know the hour is late, so what I'd really like to do is invite up Ike Casey from Subcontractors to basically make the pitch.
Step right up.
Okay, I am Ike Casey, the Executive Director of the American Subcontractors Association. Subcontractors need this protection, but not only subcontractors, owners need this protection, and the Commonwealth needs this protection. If the Commonwealth is building a building and the Commonwealth pays the contractor for the work that's been completed, you don't want that money used for any other purpose. You don't want that money to go out to offset something that's going wrong on another job. That money, that job should stand on its own. Now, the general contractors would like to retain this money, would like to be able to use this money, but I think if you think about the fairness of this, it would not be fair for general contractors to hold that money that the owner expects to be paid for the work that's been completed. I have a list of subcontract agreements. I have about, I think, 8 or 10 general contractors that use this agreement, this provision in their subcontracts. I also have a story that I'd like to give to you from a subcontractor in Northern Virginia who was harmed by this right of offset in a contract. So the subcontractors, but also owners and the Commonwealth as an owner needs this protection. I'd like to introduce Patty Peterson, one of my members from Tyndall Corporation in Petersburg.
We'd be happy to hear from you.
Thank you. Good evening. My name is Patty Peterson. I reside in New Kent County. I work for Tyndall Corporation located in Dinwiddie County. We are a specialty subcontractor in the construction industry. We employ about 300 people in Dinwiddie. I've reviewed many, many contracts over the years and fortunately work for a large enough company that has the manpower that can read through their contracts and understand them. And when a contract says that they can hold funds due me for this project to pay for any other agreement I have in place with them for some other project, just is not right. It means that the owner is financing a project, I'm financing a project, I've paid my bills, I've paid my employees, and I'm still waiting on money. And the desire to keep this language in contracts is baffling in the fact that I have an aging report that shows where I haven't been paid 90 days out from the day I've billed. A contractor has those dollars in hand. Are they mismanaging projects that they didn't know that I had some outstanding bill on another job? That doesn't make sense to me. If you are paying me to do a job, it is that job, and that agreement should stand on its own. And the next one, the same way. You shouldn't be able to move these dollars around. I'm in favor of this bill.
All right, Senator Stewart.
I'm curious, I don't know, ma'am, excuse me. We were looking at some of these offset provisions, and these are terms in a contract that you enter into with the contractor. Is that correct?
That is a term that I attempt to negotiate, and I am often successful in negotiating removing that clause. I, on the other hand, am a member of ASA, American Subcontractors Association, which is made up of many subcontractors. They aren't always as large as I am. There might be a small subcontractor out there that is doing everything they possibly can to get the work, get the employees, train them, get the work done. And either they have to pay an attorney, which bites into what little dollars they have in the job.
Well, and that was the point of my question. You are free to not agree to this, to negotiate, to enter into a contract.
Let me respond.
Let's let the
I'm gonna let
lawyers
the
argue.
legal counsel.
You
I'm gonna be your
you
lawyer.
did a really good
Pro bono.
job. Thank you.
All right.
You did, excellent.
You remember the lien waiver statute I had 3 years ago, where if there was a lien waiver in a contract, it was unenforceable due to public policy. We said you can't waive your mechanics lien rights because subcontractors were being forced to do lien waivers just to get jobs. And you know what? The construction industry absorbed that, and frankly, subcontractors have done well. This is really the same situation where if you enter into a contract saying, I can withhold money from you, not because you've done a poor job or failed to do the work, but simply I have offsets on other projects, and therefore folks cannot collect work that they've done. That's what we're talking about. That's what we're talking about.
Well, Mr. Chairman,
Senator Stewart.
this particular offset, which was provided from one of your witnesses or for you, says contractors hereby authorized to deduct an offset from any payment an amount equal to and any all sums obligations owing by the subcontractor to the contractor and costs necessary to complete the work to be performed under this subcontract. So that is an offset based upon work to be performed by the subcontractor, and that's why they're withholding that amount of money.
Right, if it's for that project. Correct?
That's correct.
Right, if it's for that project, sure.
But I mean, this is an arm's length transaction. Why do we as a General Assembly want to start dictating what can and cannot be in your contract in an arm's length transaction? That's my question, I guess.
Hold on a second, hold on.
It's not arm's length.
Yeah, well, I think you're conflating two different situations. If it's for work done on that contract and they have an issue with the quality of the work or the work is not done, they can withhold the funds. But the issue is, can they offset for a wholly separate project? That's the issue.
But I've gone to the next, Mr. Chairman.
Senator Stewart.
I've gone to the next question.
Yes.
Why do we as a General Assembly want to make that determination as to what people should have in an arm's length transaction?
Senator Stewart, we had this exact same conversation on lien waivers 3 years ago.
Well, that was a little bit different than this.
Well, it was not different. It was the same thing. You said, why should we interfere in a private contract? I understand what you're saying. What I'm saying is that the subcontractors, in order to bid on work, oftentimes are given, a pro forma contract. They do the work and then they can't collect.
Let's, are those all who wish to speak in favor of the bill?
I have one gentleman who spontaneously wanted to stand up and support.
Our time is up, so come on up and register your,
Pseudo support of it. I was both a framing contractor.
State your name.
And a general contractor. And
tell
what
us,
we're trying to do is.
Tell us your name.
Michael Wade. I'm sorry.
All right.
God, how you doing?
And you
Mr.
support the
Chairman,
bill.
I'm passionate about this. And while I support what you're trying to do, the technical issues I don't think are developed fully to incorporate itself with inside lien law.
But you
which is also
generally
federal.
like it. And I'm sorry, Mr. Wade, but.
I'm going to have to say at this point, from what I've gathered now, I'm against this bill.
Oh, okay.
Okay, I'm sorry. I'm sorry, chap. I'm with you, but I'm
all
not
right,
with you
well,
on this because I understand this greatly.
All right.
The lien law that you're trying to get, what the chairman's trying to say is you're getting into something that already exists in the transactions.
All right.
And where the real remedy is, to be honest, for y'all to be educated on this, is that for someone not to be able to get a final with the building official.
We've got, and I appreciate your spontaneity and your versatility in popping up. We've got a group behind you who have been waiting all afternoon to offer less spontaneous comments about this bill. That's all right.
No
Thanks.
worries. Excuse me.
Good afternoon, Mr. Chairman, members of the committee. My name is Gordon Dixon, and I'm with the Associated General Contractors of Virginia. We are in opposition to this bill. As Senator Stewart had just said, we do think that this is a private contract. Contracting has become a contract riddled industry. And so all of our members, whether it's the owners, the general contractors, the subcontractors, all have to abide by those agreements. The general contractors are on the hook for the agreements that they've signed on, and so they expect their projects to get done. I actually have a member here who came in from Lynchburg, Mr. Robert Lee, to talk about it and to kind of explain to you from his perspective of how this works and to answer any questions you will have on it from there.
Thank you, Mr. Dixon. Welcome.
Thank you.
And thank you for your patience.
Appreciate it. I'm Robert Lee. I am chairman of the AGC of Virginia this year. I work for an English construction company, and we do have these offsets in our contracts. And I think it was misleading, the interpretation. This has to do with funds that are dealing with the same subcontractor. In essence, if that subcontractor has multiple contracts with our firm or any of these firms, and they do not perform on one, and there are funds still available from the other contract, we use those to offset that. We are responsible even if a contractor, subcontractor signs a lien waiver saying that they have paid all of their bills. Many times we've had those occasions where all of a sudden a supplier comes up after the fact, after that lien waiver's been signed, and said we did not get paid. So again, it's a negotiation and a contract, arm's length. We do take it out of our contracts at sometimes, but again, like all of us, we try to get the best that we can and to ensure and spread that risk. So we are opposed to the bill.
Okay, thank you very much. Anybody else wish to speak in opposition to the bill? All right. The bill is before us. Senator Peterson?
I'll move to report.
All right, there's a motion to report. Is there a second?
There we go.
All right, it's been moved and seconded that the bill be reported.
We're not getting too far.
Senator Deeds, somebody has his proxy.
I may have it.
You better vote it.
He may have left the bill.
He's just here. Senator Edwards has his proxy.
John, you have
There you go. Trying to give you every chance.
All righty.
Aye, 6, no 7.
All right, can't say I didn't try. All right, last bill of the day, Senator Reeves.
Thank you, Mr. Chairman, and I thank you for the indulgence of waiting. This is a pretty simple bill.
1675.
Yes, sir. It requires enhanced penalty, mandatory minimum penalty for killing or injuring a police animal. And it was brought to me by my Commonwealth attorney, who is here to testify about a certain situation, as well as the state police. And the former superintendent of the state police is here to testify about the need for this enhanced penalty. So if you'll indulge my witnesses, Mr. Chairman, that would be great.
Thank you, Senator Reeves. Mr. Chairman, thank
Bryce,
you for your...
hang on. Do you know of anybody who opposes this bill?
No.
Ah, okay. You know of any issues, Steve? Charles? All right. I don't want to deprive you of the opportunity, Wayne.
Mr. Chairman, thank you. We're ready to go. We're ready to go.
Travis, you okay?
Oh, yes, I'm fine.
All right. The motion would be to
report and re-refer to finance.
Report and re-refer. No? Doesn't need to go to finance?
It's gotta have an M. No.
It has to have an
It has a 6 months jail sentence.
Mr. Chairman, I have a question. The only thing in this bill...
Hey, hold on. Senator McDougal? Well, we've got two choices. We can report it out, or we can, and let finance claw it back, or we can, on our own, report and refer to finance.
Mr. Chairman, as a member of the committee, I would rather send it to Senator McDougal up in finance, since he chairs that committee. And I haven't seen the report, in case that is one.
I have a question. I have a question, Mr. Chairman.
All right. Motion to report.
I have a question.
Properly seconded. Senator Edwards, I'm sorry, go
As I
ahead.
read this, the only thing this does is add a mandatory minimum of 6 months and to run consecutively of whatever, right?
Yes, Mr. Chairman.
But it's already a crime.
It is already a crime, yes, sir.
And so you're dictating to a judge what he's got to do.
We're going to enhance the penalty based on the nature of the
Well, you're not increasing the punishment. You're just saying a mandatory minimum and it's got to run consecutive.
Correct.
I'm opposed to mandatory minimums. I can't vote for those. Okay.
I understand.
All right.
Okay.
Not everybody's a dog lover.
Mr. Chairman,
Sen-
just so all the
Senator.
members know, the reason, according to what this FIS is describing, is that the kind of the median penalty that is being given by judges is 3.1 years. So that this would not be in the range that it would increase the penalties being a mandatory minimum. So that eliminates the FIS.
All right.
All right.
Move to
The
report.
motion, properly seconded, is to report. I guess now we know who loves dogs.
Ayes 10, noes 3.
All right. The bill reports. Thank you very much. The committee will rise.